You know, to the Hanover, this is Outfire, Fire's coming to the Hanover, and play. I don't just play on his head, it's nice. Next time, I could just not sign on.
Okay, knows it. Okay. Sorry. Again, to the public, we've had a couple of technical issues that we're dealing with this morning, so we apologize for the late start. We also had a couple of different housekeeping issues to take care of before the meeting. So again, apologize for the late start. Apologizing for my voice. Recognizing a quorum of commissioners, I call the March 26th, 2026 meeting of the Cannabis Control Commission to order. This meeting is being held hybrid pursuant to Chapter 2 of the Acts of 2025 and is being recorded. Commissioners Benedon, Stebbins, Roy, and myself are participating in today's meeting. All votes taken today will be by roll call. We have a full agenda today that I will generally summarize. We will start with the opening comments from commissioners, followed by a vote on meeting minutes. Before we proceed to staff license recommendations, there are 49 license renewal recommendations, 3 provisional license recommendations, 3 final license recommendations, and 1 enforcement action. There are 10 items in the commission discussion and vote section today. The first one that is listed, exit interviews overview, that is going to be tabled. Update on a search for Chief of Investigations and Enforcement and Director of Testing Compliance. An update on the petitions process for the rules of necessity, open meeting law, quorum discussion. Overview of Executive Director Performance Review Form. Executive Director goal setting for calendar year 26 and fiscal year 27, although that might be changed, the format. A discussion and update on addressing testing fraud. Approval of medical marijuana patient portal contract funded by the Executive Office of Technology Services and Security. Commission Research Center Trust Fund for grant applications, and red tape removal and regulatory timelines. I will ask that commissioners wishing to comment or ask questions during any part of the meeting raise their hand to be recognized. If needed, the commission may enter executive session, and I believe that we have appropriately noticed that we may go into executive session at some point if we do have some questions that may be impacted by potential litigation. So with those initial comments, I'll turn things over to commissioners for any comments and or updates. And I will start to my left with Commissioner Benedon.
Thank you, Madam Chair. Just a few comments today. I want to start out by highlighting a wide variety of staff-led initiatives and accomplishments from just the last month. I want to acknowledge the work of the digital team for creating a new meeting minutes portal, which makes it easier for the public to access our meeting minutes, and thanks to the legal team for increasing the frequency that those minutes get posted. I hope that this will increase access and transparency for everybody. All of the social consumption working groups, which include staff from every department within the agency, are now well underway. I'm the commissioner sponsor of the Public Awareness Working Group, and we have a terrific team that has kicked off. We're already hard at work on creating a public information campaign ahead of the entry of social consumption establishments into our market. And I'm also looking forward to working closely with our external partners as we work on our approach and messaging for that public information campaign. Something that we'll talk about more later, but I want to acknowledge the work of the testing team in undertaking a comprehensive review of lab testing protocols. This is really important to do periodically to ensure that we remain up to date on our testing processes and standards, and that we have clear protocols in place to ensure consistency and integrity above all things in the testing process. So we will talk about that more later, but I want to thank that team for spending literally hours walking me and other commissioners through their proposals and educating us along the way. So that's something really important and really valuable. In addition to a few individual meetings and conversations with licensees and industry advocates that I've had over the last couple of weeks, I do want to just acknowledge the listening sessions that we held on worker safety and licensing freeze. I always find it so beneficial to hear from everybody in the industry and advocates who take the time to provide thoughtful and insightful comments. They're so crucial to educating us commissioners on the nuances and the realities of the industry, things that we might think we know a lot about, but the people actually working day to day know so much better than we possibly can. So thank you for that. And that's all for me.
Thank you, Commissioner Benonon. Moving alphabetically to Commissioner Roy.
Oh, thank you, Madam Chair, and good morning, everyone. I'll be really brief. Since our last meeting, myself and Chair O'Brien had the opportunity to visit Solar Cannabis in Somerset, and I must give a little shout out. It's painted Braga Bridge blue after my great uncle who perished in Pearl Harbor, so it's near and dear to my heart. I also want to thank Chairman of Senate Ways and Means, Chairman Mike Rodrigues, who took time, a lot of time with us to hear directly from the owners and to learn about the facility. And we took a nice tour and learned about and discussed the current challenges that the industry faces. So I really want to thank Chairman Rodrigues for his, he was very generous with his time and really listened to us. So thank you. I also want to express my gratitude to everyone that did testify for our worker safety and our licensing freeze public hearing. I've said this many times. It's critical for us to hear from stakeholders. It really informs our policy. So thank you to everyone that either testified in person or provided written testimony. And lastly, I just want to give special recognition to our CTIO, Paul Clark, and our Director of Data Analytics, Marianne Sarkis. We are currently undergoing an expansion of our open data platform and the information that is more readily available and transparent. I've already gotten a lot of feedback from folks that find a great utility in this. And I know we're working for further transparency. I know we're in the process of crafting a data user agreement, which would provide more identifiable data. And I also want to thank them because I know they're working hard also to get our new product catalog up and ready for March 31st. So again, I just want to let them know and the public know we've gotten a lot of good feedback. Thank you.
Commissioner Stebbins.
Thank you, Chair. Good morning. Just a few updates from me. Our social consumption RVT working group met this week as the internal team. We reviewed feedback from our first meeting with the external stakeholders. Some interesting questions came up in terms of being mindful of learning styles as folks go through training, as well as whether some of the components of the training might require in-person training as opposed to just virtual. We are regrouping with our external stakeholders the week after next to hopefully hold a 2-hour brainstorming session to get their input and ideas about what should be encompassed in a social consumption RVT program. Related to social consumption, I had the opportunity to visit one of our licensees, STEM. I think everybody's familiar with up in Haverhill. This week, some folks from STEM are joining me on a social consumption panel at the upcoming NECAN event. The panel is being hosted and organized by Chris Ferrone. So we had the chance to discuss panel and information and hear about their plans to pursue social consumption, as well as see some of the improvements to their building that have been accomplished with support from the Social Equity Trust Fund. Director Williams and I joined a call with Kevin Gilnack at EON to discuss the policy questions around census tracts and SCP that Commissioner Benonon and I are working on. She and I have an internal call, I think, scheduled tomorrow with EPCO, DGAP, and the ED. Also, like my colleagues, want to thank the folks who showed up for the 2 listening sessions. And for me, there were takeaways from both sessions. With respect to worker safety, I think there are, in my opinion, some steps we can consider taking sooner rather than later. As you know, as we all know, when we passed social consumption regs, we provided that adequate PPE must be provided to an employee upon request. I was interested to hear some of the testimony from folks that showed up that talk about the extensive steps some employers are being asked to go through just to get sufficient PPE. Also like to consider whether we could have some folks in from OSHA to work with our investigative team so that our investigators are aware of some workplace safety issues when they go in and out of facilities. Next week, I am off to visit licensees in Salem, as well as the Athol Berry region. And finally, I will add my thanks to our team. I know we all got the memo from the ED highlighting a lot of the great work from our team this month. As it was pointed out, from digital research, I&E, legal, getting our finalized regs for exclusivity and secret shopper done. The testing team for going through the first batch of suggested protocol changes. And again, a lot of great work that we know the public doesn't often have the chance to see because it's behind the scenes, but it helps us get our work done. Thank you.
Thank you. And I also just want to add a couple of thanks. First of all, I want to thank our CFAO. We're going to be hearing from her later today, but she has gone above and beyond to move the issue of cannabis research forward with her diligent activities to set up a trust. We're going to be talking about that later. I want to thank the folks also that showed up for our worker safety hearing. In particular, Danny Carson Stair, who has made this a mission to get this done, to make sure that we are providing, whether it is a tip line, whether it's more stringent workplace safety requirements that we enforce. There are many, many things that we can and should be doing, but we thank Danny and the rest of the group for bringing this to our attention. And then finally, just want to shout out Paul Clark because the work, and this is especially Commissioner Roy, working to make sure that we have transparent data available on our website. And that is already bringing major information to commissioners that will help us address the issue of testing fraud. I also recognizing Director Johnson because a lot of the data that she had tried to make transparent a couple of years ago, the work that we are seeing coming forward after this has been made public is going to color a lot of our work and make the public safer and make sure that products are fairly priced. So again, just want to thank folks for that. And then moving on, the next thing we will be going through is the minutes. And we will take the first set of minutes that we're going to be reviewing and approving February 23rd, 2026. Were there any questions, comments, or amendments to that? Hearing none. Commissioner Roy, would you move that we approve as drafted the February 23rd, 2026 minutes?
So
Commissioner Stebbins, would you second that motion?
Second.
Having been moved and seconded, I'll call the roll. Commissioner Roy.
aye.
Commissioner Stebbins.
Aye.
Commissioner Benedon.
Aye.
Chair votes aye. It passes unanimously. Once again, the minutes for February 26th, 2026. Are there any questions, comments, or edits that might be suggested here? Hearing none, Commissioner Benedon, I'll entertain a motion to approve these minutes as drafted. Do I hear that motion?
So moved.
Commissioner Stebbins, do I hear a second?
Second.
Having been moved and seconded, I'll call the roll. Commissioner Benedon,
Aye.
Commissioner Roy,
Aye.
Commissioner Stebbins.
Aye.
Chair votes aye. Those two are passed unanimously. We now move to staff recommendations on renewal licenses.
I'm sure, actually, may
Oh,
I just want to thank our secretary, Commissioner Benedon, elected secretary, because I'm just on this meeting minutes portal and that's fantastic. So thank you for your leadership to see this through, and everyone, I know Anne Marie, Director Burt, and everyone that was involved. I want to thank them as well. This is really great.
It is, and it's really the digital team that put that together. It's so that the public knows, all of our meeting minutes have long been posted, but they were posted just interspersed with all of our other hundreds of public documents. And now there's a dedicated page just for meeting minutes, executive session minutes as well. They're in a more logical order. So thank you for acknowledging that. And it's great that the team put that together.
Thank you to everybody involved. Thank you.
yeah, no, and I second that. Thank you very much because I've been frustrated on multiple occasions.
I've had to try
to find
find
it.
one.
I can't find it.
Yeah.
So anyway, thanks everybody for the work on that. All right, so we are moving on to staff recommendations on renewal licenses. And do we have staff in here? Will this be Director Defoe? Is she here? She,
There she
I'm
is.
here, Madam Chair. Thank you.
Mr. Cook, good morning.
Good morning.
All right. Again, we have Manager Asuko Dufault, and she is recommending 49 license renewal recommendations. Commissioner Roy?
Madam Chair, I believe your intent was to table number 11. I don't know if you want to start with that.
That, okay. Yes, okay, all right. All right, so we will table the renewal license of debilitating medical condition treatment centers, number MCR 141003. Are there any other questions or comments? The Executive Director?
Thank you, Madam Chair. So I know currently up on the website, our next meeting is April 16th. I know the intent of the board is to post as well at least one other meeting prior to that on or about April 7th. So we would table this to that time and bring back some more specific information and work with this licensee on a question that came up through the process and bring all that back to the board on or about April 7th.
Okay, great. Thank you. I missed that. Right, it's cold. So excuse me. So anyway, we have, so this will be, I will entertain a motion unless there are any comments from Manager Dufault or any questions from my fellow commissioners. Commissioner Benedon, I will entertain a motion to approve the renewal licenses of 1 through 49 on our agenda, tabling number 11, debilitating medical condition treatment centers. Do I hear that motion?
So moved.
Do I hear a second? Commissioner Stebbins?
Second.
Having been moved and seconded, I will call the roll. Commissioner Benedon?
Aye.
Commissioner Roy?
Aye.
Commissioner Stebbins?
Aye.
Chair votes aye. They pass unanimously. Moving on to staff recommendations on provisional licenses.
Okay, the applicant here is Exceptional Grow LLC. The proposed location is 1 Cabot Street, Suite EG, located in Holyoke. They are seeking a marijuana product manufacturing license. This applicant received expedited review as a social equity participant. Commission staff has reviewed the application for compliance with applicable laws and regulations and are presenting it for the commission's review and vote.
Are there any questions or comments regarding Exceptional Grow LLC? Hearing none, Commissioner Benedon, I will entertain a motion to approve the provisional license of Exceptional Grow LLC.
So moved.
Mr. Stebbins, do I hear a second?
Second.
Having been moved and seconded, I will call the roll. Commissioner Benedon,
Aye.
Commissioner Stebbins,
Aye.
Commissioner Roy,
Aye.
Chair votes aye. That passes unanimously. Moving on to Great Northern Wellness.
The applicant here is Great Northern Wellness LLC. The proposed location is 180 Elm Street, Unit E, located in Pittsfield. They are seeking a marijuana retail license. The applicant received expedited review as a social equity participant. Commission staff has reviewed the application for compliance with applicable laws and regulations and are presenting it for the commission's review and vote.
Thank you. Are there any questions or comments regarding Great Northern Wellness LLC? Hearing or saying none, I will call the roll. I will entertain a motion, Commissioner Roy, to approve the provisional license of Great Northern Wellness.
So moved.
Commissioner Stebbins, will you second that?
Second.
Having been moved and seconded, I'll call the roll. Commissioner Benedon,
Aye.
Commissioner Roy,
Aye.
Commissioner Stebbins.
Aye.
Chair votes aye. It passes unanimously. Moving on to Sun Fusions.
The applicant here is Sun Fusions Inc. The proposed location is 53 South Maple Street, located in Brooksfield. They are seeking a marijuana retail license. The applicant received general review. Commission staff has reviewed the application for compliance with applicable laws and regulations and are presenting it for the commission's review and vote.
Thank you. Commissioner Stebbins.
Thank you, Chair. Just a note on this one. I was intrigued to see in their positive impact plan, they plan to make a donation to the Social Equity Trust Fund. As we know, when we did some reg promulgation, this was something that we prescribed would be, could be a component of your positive impact plan. I think at some point it'd be interesting if we reached out to the executive office to see, are they seeing donations and who are they coming in from? I don't know if they,
We should be tracking if they say it.
if they say it and who's doing it,
That's
but
a
it'll
very
be
good
interesting to see who might be following up. But hopefully, maybe we could invite them to a future meeting and they can share whatever information they have.
It's an excellent idea. And I know that Commissioner Wright, and this is actually one of the things that we hope to, maybe take
Yeah,
a look
if
at.
I may.
Is how can we streamline the positive
Yeah.
impact plans?
It-
Because frankly, we're hearing from social equity applicants who are already being overly burdened by the way we craft and require positive impact plans. And there's a way to have that positive impact, but do it in a less burdensome way. So I don't know if you have any.
Yeah, I know we're going to talk about red tape. And this is clearly a source of red tape we're hearing from, and the impact is, I'll use your word de minimis, Chair. We're not seeing that necessarily the impact. And even though it was well-intentioned, exercise, it's just not, it's causing, they get hung up on RFIs or just, and people are spending resources they don't, necessarily have for minimal impact. So I think we need to re-examine and reimagine the way we look at impact. And part of that would be retooling and instead of, we want quality impact too, right? And so one of those ways could, make it streamline it, but make it impactful. The Social Equity Trust Fund, Equity Works Career Hub, that's huge impact.
Career Hub has to be said 3 times a day. We're
Equity
actually-
Works
We're
Career
actually
Hub.
adding that, Saleha Williams, she's not here, but I'm sure she's watching, but,
Yeah,
we are all going to be, or I don't know all, but many of us are going to be incorporating that into our, regular signatures.
that's
so that
right.
we're
Your idea, Chair.
Promoting, no, we're constantly promoting, that our licensees use Equity Hub work
Right.
to find employees and to promote social equity.
Right, so more to come on positive impact plan, but like to your point, Chair, it's the equity community is saying too, this is very burdensome and it's not producing the impact, so let's revisit it.
And this is something, and also Commissioner Benedon, because this is, because obviously you're sitting in what is, it's more than that, but what is the sort of, what has been the social equity seat? It would be great. We have open meeting, prohibitions, and some of this might be in the red tape group, but
But if you could delegate
I
us,
might want to sub-delegate that work
yeah,
so that you can then come
like
back.
biennial renewals,
Yep, you have a
right?
sub, yes, so just to explain to everybody who doesn't understand the half sentences that I'm saying right now, we have a subgroup that is looking at biennial renewal of licenses that is part of our red tape removal effort. If we could actually, and that would be great to have the two of you
I'd love
working
to
on
do
that, making sure that we are fulfilling the mission of promoting positive impact, but also doing it in a way that makes sense. And then with Commissioner Stebbins, it's like, yeah, we're asking them, we don't know whether or not, so we probably need to figure out whether or not that has actually happened and what that process might be. So thanks to everybody for pointing that out. So anyway, okay, and again, I do apologize to the general public because again, we can only talk in groups of 2. This is the only opportunity where we can all speak together and not be in violation of open meeting law. So sometimes people might think that we are over talking, oversharing, but it's only because we are prohibited by open meeting law from having more robust conversations outside of public meetings. So with that, get back to the issue at hand. Sun Fusions Inc. Sugo, because I've talked for so long, I can't remember if you've already walked through it. Have you?
I walked through it, Madam Chair, and I believe you
Okay.
guys are in the middle of taking the vote.
Thank you for reminding me. Okay, so it has been, Commissioner Roy has.
I'll do it again.
Commissioner Roy
So moved.
moves. Commissioner Stebbins, you second.
Second.
Having been moved and seconded, I will call the roll. Commissioner Benedon,
Aye.
Commissioner Roy,
I,
Commissioner Stebbins.
Aye.
Chair votes aye. Sun Fusions Inc. passes unanimously. And now we have final license staff recommendations. 1 through 3, Arrow Cultivate, Motive 420, marijuana delivery operator, Motive 420, marijuana product manufacturer. Are there any questions or comments from my fellow commissioners? Oh, I apologize. Hearing and seeing none, I will entertain a motion to approve all 3 of these licenses. Commissioner Roy, do I hear a motion?
so moved.
Commissioner Stebbins, do I hear a second?
Second.
Having been moved and seconded, I will call the roll. Commissioner Benedon,
Aye.
Commissioner Roy,
I,
Commissioner Stebbins.
Aye.
Chair votes aye. Now we are moving to enforcement actions. Oh,
Ask a question
please.
about licensing. And I recognize that Director Koval does our monthly licensing presentation, and this is not that monthly meeting. But I did notice when looking at the renewal licenses, which we approve in a group, that there was one MTC, Medical Treatment Center, Berkshire Roots, which was specifically noted as not cultivating under their MTC vertical. Instead, they do all their cultivation under a separate cultivation license, keep the product as adult use in metric until they then transfer it to the medical. But they do have a tier designation under their MTC license. And so what I'm wondering is, are we essentially double counting when we look at total canopy, since they're not cultivating under something that they could be cultivating under?
Executive Director.
Thank you, Madam Chair. And I think within that reference to moving one item to April 7th or thereabouts, one of the items I'll discuss with the chair of potentially putting on would be to discuss how we treat tiers for MTCs. A lot of that is inherited from the DPH days, and it may impact how we're approaching the general subject of that. Your question as it relates to how it is reflected in the aggregate data that is presented on a monthly basis, I would have to rely on Director Koval, but I do think that we could add that to that agenda and go through that all together in early April, if that makes sense.
Yes, that's fine.
Thank you. Is Attorney Gooden coming up to present this?
He's getting ready for the next one.
Okay. The stipulated agreement.
Yes.
Oh, okay.
It's behind the pole.
Oh, okay. No, I saw him walking and he disappeared. It's like, like a little kid, you go like this, you can see it anywhere. It's amazing. Tim is currently our co-chief of investigations and enforcement counsel.
Madam Chair.
Please, oh, thank you. Yep.
Morning, Madam Chair, Commissioners. We are here, or I'm presenting today for consideration by the board, a stipulated agreement relative to Boston Bud Factory Incorporated, holding license numbers MR 281525 and MP 281397. As well as a person having direct or indirect control of both licenses, Mr. Franklin Daly. His agent registration numbers are AR 287654, AR 287627. So as I said, for your consideration is a proposed final order and stipulated agreement relative to this licensee and this person having direct or indirect control. This is this stipulated agreement is back before you. It was previously considered on October 1st of last year and rejected at that time with a specific direction or directions from the board to go back and renegotiate on certain elements. So I won't delve into the specific facts at issue here. All of those are contained in the stipulated agreement. I will just offer a brief reminder on the specific violations that we are finding in this order. So the first violation is that the licensee did not comply with limited access area requirements in violation of 935 CMR 500-110 subsection 4. Violation 2 is that the licensee engaged in prohibited advertising practices. Violation of 935 CMR 500-105 4B12. Violation number 3 is that the licensee failed to post prices and strains available for purchase in violation of 935 CMR 500-105 4A6. And then the final violation is specific to Mr. Daly, identifying that Mr. Daly engaged in deceptive conduct in violation of 935 CMR 500-0321B and 500-301 subsection 7. So the proposed resolution at this time is that the licensee will pay a $25,000 monetary penalty payable by check or money order. Excuse me. To the Cannabis Control Commission marijuana, or the Marijuana Regulation Fund, due in full no later than 12 months from ratification of this order. Additionally, there will be a 14-day suspension for Mr. Daly and his agent registrations, as well as a 14-day suspension of another person having direct or indirect control, Mr. Carlos Sarno. During the period of the suspension for Mr. Daly and Mr. Sarno, they will not be present at respondent licensee's premises. They will not collect a salary or be paid by respondent licensee, work or volunteer at any marijuana establishment or medical marijuana treatment center, or conduct any other activity that would otherwise require a valid agent registration. In addition to those specific penalties, there is also affirmative relief that is contemplated in this action. As we've discussed in previous times too, we do, with stipulated agreements, we'll incorporate some affirmative relief, which is intended to, one, account for enhanced compliance monitoring following the finding of violations, as well as incorporating certain conditions with the goal of bringing the licensee back into compliance and ensuring future compliance. So here, the licensee of Mr. Daly will be subject to a 12-month probationary period. The licensee has also agreed to submit notice of any planned brand name sponsorship or advertising 72 hours prior to engaging in those activities. And we also have incorporated some additional training requirements. All of licensees' registered agents, including staff, including management and owners, shall complete basic core curriculum for responsible vendor training and notify the commission when that is completed, the dates of the training. Additionally, respondent or Mr. Daly will identify an ethics training course from an accredited provider, provide that course information to the department for approval, and complete that ethics training and notify the commission upon completion. And additionally, we have incorporated automatic assessments and escalating penalties therein for any violations of the terms of this order. So with that, Enforcement Council staff recommend ratification of this agreement as an appropriate resolution of the violations. Taken as a whole, we believe that the agreed periods of the monetary fine or penalty in this revised agreement, as well as the periods of suspension for Mr. Daly and Mr. Sarno, in addition to the affirmative relief that will ensure future compliance, represent a significant deterrence for any future violations for this licensee. So thank you for your attention. Open or available for any questions you may have.
Thank you. Just a couple of different things. I think you know that my biggest concern about this is how long this took. It's 4 years old. And I will tell you that I received a tip from someone as chair in 2022. And I think that one of the things that does need to be included in any investigation and enforcement summary is we need to understand the dates. When did we first, if we received a tip, when did the tip come in? What was the first engagement that our investigations team has? Because it's my understanding that this investigation took 2 years to complete. Now, I know that when we were doing our 2x2 meetings, there were explanations as to why it took 2 years, but again, you can see other instances where there is inversion. I'm trying to remember in particular, and I think it was even in 2022, there was another particular case of inversion that was reported in or around March of 2022, which was wrapped up, agreed to, and finalized by August of 2022. So one of the things, and we've had this conversation offline, and one of the things that I'll be bringing in future meetings is that we need to tighten up the timeframes within which we are allowing some of the formal processes to move forward, as well as the informal negotiation. It's my understanding that the commission made a decision to allow a request for a hearing to go beyond 30 days, which is written in the, and again, this before you were in this role. It is my understanding that a former general counsel signed off on that. And so I think that it will be incumbent upon us as commissioners, especially because the auditor has made comments about disparate treatment. Why is it that some of these things happen within a matter of months? Why is it that some of these investigations take 4 years? And again, this is one of the outliers. So this is, again, not a critique or criticism of you, but I think it's something that we as commissioners, in looking at the regulations, may well have to do a better job of tightening up how long we have to do an investigation. If an investigation takes longer than a certain amount of time, this should not be opaque, to commissioners. And commissioners should know that all licensees are getting the same due process under 30A. And if some investigation is taking a much longer time, I don't know what made this, I don't know, because I haven't been able to, I don't know what made this particular investigation take 2 years. I don't know what the complexity was, but we need to, as commissioners, not be kept away from information because we're worried about protecting the due process rights of licensees. Meanwhile, this is something that has taken a long, long time. This company has been in business. They have been to continue to act, without any sort of punishment or fine or anything like that. So I just want to make sure that we are moving more towards equity. And I think that we as commissioners can do a better job to help the staff say, hey, we've got to move this along more quickly, and would love to, get your feedback on some of that stuff. Very good.
Thanks, Madam
So
Chair.
the first question is, when was this tip first received?
When a tip was first received, I would need to go back and grab that specifically. I don't have that in front of me right now.
Oh.
So looking at the facts of record here that were identified in the stipulated agreement. The first investigative steps, or the actual investigation, looking at when they were actually conducting the first unannounced inspection, that was March 18th, 2022.
Right after St. Patrick's Day. Okay. Thank you.
And Madam Chair, generally to the other comments or feedback that you just identified there, I think happy to work with the executive director, identify potentially other information that could go into the executive summary, anything along those lines, but would definitely.
This is something that I think we need to have these summaries. We need to know, when was this first reported to our team? When was the first interaction following up around the particular complaint of violation of regulation, violation of criminal law? We need to know that, and then we need to put in place some sort of a framework so that the next time an audit comes out, and if there is an appearance of disparate treatment, an appearance that we're not collecting fees in a timely fashion, we need to be able to make sure that we as commissioners are enforcing the law, especially when a lot of what happens we can't see because we're on the other side of that 38 and open meeting law. Well, so we can work on that further, but it's just a point, and this is not the only one that we are and will be talking about that has taken a long time. So I think that we need to do a better job as commissioners to establish standards that ensure that everyone is being treated equitably. Commissioner Roy.
Thank you, Chair. AC Gooden, would you agree with me that our arcade machines appeal to young people? Just an opinion.
Commissioner Roy, I think it, depending on the circumstances, they're geared for a variety of different audiences.
Which could include young people.
It could.
Thank you. And at the block party, observations from our investigators that Boston Bud Factory were not doing age verification. Is that part of the record of fact?
Commissioner Roy, so in the commission findings, paragraph 73, Section E, one of the commission findings here is that Boston Butt Factory did not employ reasonable measures to keep its advertising at the block party from reaching event attendees younger than 21. And for C, as event sponsors, BBF controlled access to the block party. So those are both related to one another.
Do we know if the arcade machines were at the block party?
That is not in the findings specifically.
Madam Chair,
Please.
I'd like to request to go to executive session.
I believe, and we have noticed, because there could be potential litigation. And also we need to understand what our role is as finders of, well, the finders, not the finders of fact, but as the judges here, we need to understand the decision that we make and what potential liability that could generate for us. So if you'd like to make that motion, then we go into executive session. Do I hear a second?
Do you have a question?
Any questions on that?
Or I just wanted to question if we are proposing to go into executive session, what the basis is for there being clearly and imminently threatened litigation.
There is no imminent litigation, but I think it is to discuss potential litigation strategy, because at this point in time, we have certain decisions that we can and should make, and we want to understand how we can best act, given this is now the second time that we've had enforcement counsel place in front of us a stipulated agreement. So if we reject this, and we can reject this finally, the last step would be to go to court. And so I think we're trying to understand exactly what we can do to either say, but your next step is going to court, or we're going to maybe make some recommendations that could avoid going to court. That's what my understanding is. This is to create both either a negotiation strategy or a litigation strategy. And I believe that this would be appropriate.
I'm not sure that I'm
Okay.
comfortable, but others might vote otherwise.
So-
It doesn't, to go into executive session under the litigation purpose, it should be to discuss strategy with respect to pending or clearly and imminently threatened litigation. And I understand the explanation that litigation could result.
Mhm.
I'm just not sure as one commissioner, am satisfied it meets that threshold. We could always take a vote.
Well, I'm just saying, if you don't, obviously you are the person who knows open meeting law the best, and we're trying to make sure that, so again, then we should just be asking questions.
In open.
I'm okay, Commissioner Ray, I'm okay with that.
Okay. And what stands out to me in the affirmative relief is I feel as there's something missing in the affirmative relief. And I sit in the public health seat, I've spent my career around youth prevention. I see arcade machines as very appealing to young people. I see a block party where there was no age verification, where there could be young people. And I don't feel that the affirmative relief speaks to youth prevention in any way. It talks about ethics training. It talks about, there's the fine, there's the suspension. But I don't see anything that speaks to that. And as a person in the public health seat, it's very alarming to me that they had pre-rolls, not for sale, whatever, an arcade machine, and no age verification at a block party. And so I think they need to be better versed in youth prevention. And so I would propose additional affirmative relief that speaks to that, because I feel it's silent on that. So that's where I was coming from on that.
And my additional commentary is also, I would also, as a commissioner, I would like the background, and I don't know if you can present. See, this is also, there's methods of investigation that I'm told, we can't tell you this stuff. So I am requesting, and maybe we can get this during the break, I would like to see the timeline. I want to know who went, where when, because if memory serves, and I didn't know the name of the company, but if memory serves, I had someone call me, I believe it was in September or October of 2022, that it had been going on as long as September of 2022. So can we get, and is that public information? Can we share that with the public, how we conducted that interview? So we are comfortable that given this 4-year timeline, that this was done appropriately.
Madam Chair.
Yeah.
So with respect to some of the information that you're requesting, particularly as it relates to, is this information public? I think it'd be best for me to defer to the general counsel on some of those elements.
Would you like to request his opinion? Because I would like that information, because if I received a phone call in the fall of 2022, I would like to know what our staff did from March until September, October. Because again, it's 4 years, and that's where I'm concerned. So would you like to get a little more sunshine on this issue? Would you like to get that? Because this is also part of the potential need to go into executive session, because I am looking for information that really drills down into how we did our job.
Yeah, Madam Chair, I think allowing me some time to have an additional conversation with general counsel in terms of kind of what those parameters might be would be helpful.
If the general counsel wants to step up and maybe provide us his opinion on this.
Mine's coming up. Can we ratify with a condition? In other words, subject to youth prevention, affirmative, really, can we, is that an available tool to us? Ratify subject to?
Madam Chair.
Please.
So Commissioner, again, here, this is kind of a question that relates to the board's authority on what you may do with respect to this.
Yes.
Stipulated agreement.
Yes.
So I think general counsel may also be best positioned.
Absolutely. Okay, thank you.
General counsel, I don't know if you heard that last question. What can we do? I mean, one of the other points that I saw here is, a $25,000 monetary penalty paid within 12 months. That means it could be a full year. And knowing how many businesses are in receivership, this is one of the things that I'm very concerned about. Is justice delayed is justice denied. And we know that we have another one coming up that even if we have some serious penalties and fines, is unlikely to be collected on behalf of the Commonwealth. So that would be one of the things that I would almost want a prorated monthly payment to be coming in over the course of those 12 months. I think that giving them another year after 4 years, this will be 5 years before the real pain point is imposed. So that would be something else. So Mr. General Counsel, can we discuss and provide amendments to this stipulation?
Thank you, Madam Chair. Thank you for recognizing me. In response to the question from Commissioner Roy, I'm reading from our regs at 935, 500 sub 7, which reads, Commission's authority to review, approve, or reject informal dispositions. At any time, the Commission or a Commission delegee may, in its discretion, review, approve, or reject any informal disposition, but only on a showing that the alleged violations have been corrected and a submission of a written waiver of its right to judicial review. So I read that section to provide that the Commission's actions and options are limited to either approving or rejecting at this stage.
Do we have the ability to reject? Because I don't want this to go back. I don't want this to go back through the loop in the cycle. So then we can, so what would be the course of action if we don't want this to go back through another many months of negotiating something? Or if we, could we say, this is what we want, come back with a stipulated agreement by our April whatever meeting. And if you can't do that, then just go to court. Can we do that?
The answer, I think, is mostly yes. So you can now direct and give direction to the EC in terms of what the board would consider to be acceptable, and then the EC can take that information and proceed with.
And can we set a time limit?
I see no problem with setting a time limit. Defer to the EC on just the amount of time that he might need to do that. You did say
So
something
this is,
about.
I'm just saying, this is very simple because this has been 4 years. Okay, so from my perspective, and I may not have, two other commissioners who agree with me on this, but I feel this is kind of the end of the line. And I still see a couple of points here that are still troublesome to me most particularly. I don't like the in 12 months because we have so many businesses that are, near closure. I have no idea the financial health of this company. And I don't know if we kick this down the road for another 12 months to be made whole, I'm not sure they're gonna ever pay it. So that's my, concern that I raised with the resolution here.
Madam Chair.
Please.
Thank you. So first, just speaking to the time period and what General Counsel had identified as well. I think what I'm hearing in terms of feedback from the board is one, perhaps tailoring the educational components, so maybe RVT, changing that to something that is more specific to,
Or in addition to.
either to say that this is closer to advertising, diversion, allowing the licensee perhaps to identify one of those similar to the ethics training, give us the curriculum, and then proceed with that training. Incorporating something like that, I think it could be done relatively quickly. Just wanted to provide also an explanation in terms of the time period that is spoken to in paying the monetary fine. Again, that is an element that was reached through the negotiation with the licensee. I will also note with this too, we have had instances in the past where we've allowed multiple years to pay a monetary penalty. Generally speaking, we are shifting away from that practice. This 1 year period, the licensee, the retail license is expiring, set to expire right now at the beginning of April. So if this is ratified now, that time period essentially lines up with their renewal period. So that is where that 12 months is built in, just as an explanation in terms.
No, I totally understand it, but the fact is they've had 4 years. They've had 4 years to contemplate, 4 years to set aside a little, jar that they're going to, and in looking at what happened here, also looking at what you presented to us about what we're going to be doing to take some of the discretionary thinking, because we know we had in one case, the 60,000, 2 joints that were diverted, $60,000. Initially, the staff suggested that 2 joints diverted $140,000 for 2 joints that were diverted. I don't know how many, I'm assuming this is considered an act of diversion. So I know that we are trying to take that discretion out, that some people get lesser penalties, other people, are asked to give us a percentage of what you have in the bank. That has to be, and you are doing the work on that. Is this consistent with what you have put forth in this proposed? Because I see multiple, numbers of diverted product. I see the added, not being truthful when the investigation was occurring. Do you think that this is consistent with this new guideline that we're putting together?
Madam Chair, so I suppose first I would caution against specifically trying to relate one instance to another. Each of these are handled on a case-by-case basis. Additionally, when we're looking at the prior action that you referenced, there was it did not all boil down to just diversion of a couple of pre-rolls. It was also the mistruth, et cetera. What I would say in this agreement, yes, but this agreement is also tailored. There is specific accountability for the 2 owners here.
But this is the issue, is that when we have too much discretion, I have heard the issue and the other one was, well, and that was what I heard, is that there was lack of honesty, right? We have that factor here. One was the number, one was 2. This is, I don't know, dozens, hundreds, I don't know. So there seems to be too much discretion. And so again, I asked you in looking at what you see, is this consistent with what you folks are going to be presenting to us that takes a little bit of discretion, provides a little bit more clarity to licensees so they know you divert a couple of joints, you better tell us the truth. You don't. These are all of the additional penalties and circumstances. Looking at what I saw, I don't know if that's consistent. Do you think it's consistent with what the draft that we saw?
And I do know the executive director.
Executive director.
To that question, I wasn't jumping in. I was just wanted to highlight as well, some of what also is included here was the feedback from October 1st. So I know Enforcement Council went through the whole package, but just kind of comparing what was in front of the board on 10/1/25 versus March 26/26. No fine in the package in October. That went back. EC worked through that process and came back with a package. And I know the question I'll let the EC answer in terms of you're asking to kind of put it in perspective of the process that he's proposed and gone through with commissioners and myself. The other thing I would note is some of the significant feedback that the EC was able to incorporate here from the board was you did not want the hourly employees to be impacted and be negatively impacted through the actions that was out of their control. And so within what you have now is rather than a business suspension, it is a individual suspension for those actors that are deemed to be the ones that had that ability to correct that action. And therefore the business and the hourly employees don't get necessarily impacted, but those individuals do. So I just wanted to highlight those
And
differences.
I would say I really applaud you for doing that, because that was one of the first things that bothered me, is that it's that the principals were not going to be as impacted as the Commissioner Roy first.
Thank you, Madam Chair, and thank you, Mr. Executive Director, for those points. I do applaud you because we were concerned about the hourly workers, so that was great work. Where I'm uncomfortable is with the affirmative relief, something around youth prevention or even diversion, and the $25,000. So if I read this correctly, they could literally have 365 days and pay on the 365th day that fine. Where, like we did with Assured, we had it on a schedule. And so I'm wondering if that could be revisited, if it's $2,083.33 a month, or it's $6,250 per quarter. But I'm not comfortable waiting 365 days before they pay this fine. So
Thank you. Commissioner
Yeah.
Stevens.
Oh, I'm sorry.
Sorry.
And I know, Chair, you want to avoid delay, right? Justice delayed is justice denied, as you say. And so I'm wondering, EC, would 30 days be adequate, and you could bring it back to us or on the 4/16 meeting for us to ratify if we are in agreement on what needs to be modified?
Why don't we raise the points that, I would like to see payments not wait until the end. I don't think we should give them another year.
Yeah.
So that's one of the things that I would like to see here. I think Commissioner Roy has made some comments about additional education, but again, in terms of age gating, Commissioner Stebbins, I don't know if you had another point, and just want everyone to kind of weigh in, because I do not want this to be delayed, and this is up or down. It's either they like it or they don't like it. And this is where we have to, negotiation is a good thing until it becomes a delay tactic. And so I don't want to delay anymore. So I don't think that this is what we're doing this in open. We're not doing this as so, making sure that people know this is where we're going. This is what we want to do. And so I don't really want to wait any longer. It's either, yep, we're going to do it, or no, we're not going to do it and we'll go to court. So Mr. Stebbins.
Thank you, Chair. And by the way, Chair, I do agree with your points about getting a better sense. Obviously, every investigation is not the same, but I think to the Chair's point, trying to figure out why this took so long, and you have provided some of that explanation, but obviously for the health of the industry to move some of these investigations along quicker so people aren't kind of hung up in the process or continuing to operate necessarily. I like the new version of the stipulated agreement. It's based on the same facts that we already knew. I think it does adequately go back to the conversation that we had back in October, that we all agreed we didn't want to see the individuals worked who had potentially no awareness of the infraction that was going on, and holding the licensees, the decision makers, kind of responsible. And I do appreciate the comment, the discussion around the fine and maybe spreading it out. It's similar to the approach we took with Assured. what we're looking here for is consistency. So another licensee would understand that the commission is getting into the mode of, here's the penalty, this is why, this is, the individuals that we're holding responsible, not the entire license, or not all the agents that work for that licensee. I do have, so I'm happy to kind of entertain that conversation. The other things that, again, just to point out, and you and I talked about this with respect to RVT training, and the chair and I can go on and on about RVT training. We do want to at some point make the training appropriate to potentially what some of the infractions are, right? So we need to do that kind of going forward. Another element that I would add to this, and I think we've talked about, or I've raised it at a public meeting, is whatever final stipulated agreement we come to that we sign, we direct the ED to sign on our behalf with the licensee. I want to make sure that a copy of that stipulated agreement is transmitted to the host community in all cases, just so they're aware of the activity, our findings in our enforcement work. So thank you, Chair.
Thank you. Commissioner Benedict?
Thank you. I'll start by noting that I wasn't on the commission when this was discussed back in the fall, but I did watch the meeting video. And I want to commend the staff for what I think was very thoroughly and directly addressing the concerns that were raised at the time. At the same time, I do very greatly share Commissioner Roy's concerns that the stipulated agreement here and the stipulated remedy, although it reflects the board's concerns as expressed back in the fall, it doesn't really address the underlying issues. As a general approach, I would always prefer to see a remedy do something along the lines of training or some kind of remedial action that directly addresses whatever the underlying violation was and ensures that it won't be repeated. I'd rather see that over any financial penalty, to be honest. For some companies, and I'm certainly not suggesting this is the case for this particular licensee, but for some, a financial penalty is just a cost of doing business. I'd rather make them learn and make sure that it is not going to happen again. So I do wish that that were in here. That said, I go back to my first point, which is I'm concerned that this was discussed thoroughly back in the fall. That particular issue, I don't think was raised as one of the concerns or deficiencies with the stipulated agreement that was brought forth at that time. And so now staff and the licensee have negotiated. They've come back to us with something that they all believed addressed the concerns. And we're saying, oh, but there's this additional thing. And I know we're not going to keep doing that forever because I think all of us want to see this wrapped up and sealed. But I do have concerns about them doing what we collectively as a board told them to do, coming back with something and then saying, actually, here's another thing. As much as I would like to see that in here, it doesn't seem right. It doesn't seem right to me in this situation.
Thank you. Commissioner Rudd?
My question to the chair, to the general counsel, is on 500, 507. So it's up or down, approve, reject, up or down. The next time we open the regulations, would we have the ability to approve, modify, approve with conditions? Can we, so this isn't a regulation, this isn't in statute. So we would have the ability to tweak this to give us more flexibility, to Commissioner Benedict's point. And it's hard because we don't bake the cake and we don't pick the ingredients. We just see the final cake and say it's good or it's not. So that makes this cumbersome, you know, and I think what was glaring to us at the time, I was there, was that we were, the overarching concern was, you know, people that work there were going to be without a paycheck and without a, like, they were getting punished for things that they didn't do. And I think that just superseded everything else. And do I regret not advocating for youth prevention? Then I do. But I think, to be honest, the biggest thought was, how do we keep these people employed at the time? So I'm wondering in the next round, and if you and your team could give it some thought on what we can do to provide a little more flexibility in this language, so we don't have to say this or this, and then, you know, so that's all. I just, you know, and in hindsight, I wish I would have advocated for youth prevention, because arcade machines and no age gating is, to me, a problem. Absolutely.
And if I can just also make a point, we did, I think it was clearly communicated that we thought that there did need to be a more consistent, and we raised the issue of consistent fining. And this is where I don't see this as consistent. And I raised this, I don't see this as consistent with what we've done in other cases. And for some larger companies, I do understand that it's a cost of doing business. It's a cost of doing business when you're a really big testing agency and you not only have a big fine, but you also get additional time to pay that fine. Having additional time to pay a fine is a benefit. And so that is where, you know, when I did, we did reject this the last time, I probably hadn't dug into how long this had been. I only recently found out exactly how long this was in process. So this is also why we now, I think that the staff has gone a long way towards moving more closely to what we suggested back in October. Again, November, December, January, February, we're now in March. They've had an additional 5 months to negotiate this. And so I think these are small tweaks that I think can be managed. I don't think that it's taking any of the discretion away from the staff, because I was very clear. I said, I think a financial penalty needs to be in line with what I've seen with other things. I don't see this as in line. So again, I totally understand that we need to have the staff, but this is also why the point that I made in the beginning, these things can't go on for 2 years. And I'm telling you, I received a tip in September. So I don't know if even after this investigation began, I can't comment to that. All I know is someone called. Was it months late? Was it, you're there now, Commissioner O'Brien, and you need to know this was happening? I literally called the gentleman, former state rep, who runs the cannabis program in Holyoke, because I was confused. I said, how do they have people, you know, smoking joints on site? I don't know. And I thought it might have been like what they have here in Worcester and what they have in Cambridge. I didn't know because I was new to my job at that point as well. But I will tell you, someone called me complaining about this. And again, I was always trying to be, just give it to the staff, you take care of it. So it's been 4 years. We were very clear. I was very clear that I want consistent. If we're going to have a fine, it has to be consistent with what we're doing for everybody else. So this is my only thing. And also, since last October, I don't think that I was as fully aware at how much the industry is in crisis right now and how many businesses, big and small, are on fumes. And so what I'm concerned about, because we are about to see another licensee on fumes that probably will have significant fine and may not be able to pay us. So that is, a lot has happened since October. And I just want to make sure that we don't kick this down the line for another 12 months. I think it's a small tweak to say, don't wait till the end, but pay it over time. So anyway, that's my point. Commissioner Wright.
Thank you, Madam Chair. And I don't want EC Good and your staff, this is not a rejection, because you guys did a great job. It's, if we don't just have that option in the regs, approve with a condition. And if we did, I would approve with a condition. We just don't have that option. But, you know, it's the only 2 areas of concern is giving them 365 days to pay. And then the training should fit the alleged compliance issues. And I don't feel like RVT necessarily fully does that. So I wish there was an option, approve with a condition, and that's what I would do. So I don't want you to feel like this is a rejection. It's not.
Yeah.
Thank you, Madam Chair. So Commissioner Roy, other commissioners as well, just wanted to kind of just make sure that I'm summarizing some of these correctly. So you totally understand in terms of the adjustments that the board is really seeking here in terms of the fine time period, perhaps incorporating 1 in terms of the 1 year being too long, but also 2 incorporating maybe some payment.
I think it's really small tweaks. I think
Yeah, they're tiny.
we're there. It's just making it.
Yep, I believe I understand where the intent is on that. Just thinking about kind of general time period. If there was a time period that the board wanted to identify, and then
I'm wondering if
to
we
come back
could,
whenever we're able to.
if we could suspend this conversation, and I wonder if you could get a sign off today.
I think attempting to do it today might prove difficult, but we could try moving
We
it
might be able to do it today.
as Mr. Daly and Boston Butt Factory represented by council. I would need to talk to
All right.
council. I can't
I'm just-
talk
I'm just-
specifically to
I'm just saying,
their
I don't
clients.
know if today you could get on the phone and we could put this to the end of the agenda and we could, otherwise I'd like to put this, I don't want this to be taking time. This seems to be a minor tweak, seems to be reasonable. It seems to mostly comply with what was said in October 2025, all the work that you guys have done over the past 5 months. I think that it,
Absolutely. And Madam Chair, I agree. We don't want this to kind of be prolonged
Yeah.
further than it needs to as well.
We do.
But
well, I know that because they are represented by council, you would want to talk to their council.
I need to talk to their attorney.
Okay.
Would
Their
April,
counsel?
sorry. I was just gonna ask if April 16th made sense, but
Thank you. If I may, to that point, I do wonder about OML compliance and just, as we are thinking about amending the agreement, having that, available for public inspection in the packet for a future meeting, I think it makes more sense to me from a compliance perspective. So just like it now.
How do you feel about that?
Mr. Donovan?
I'm not sure I entirely understand the concern.
Well, so as it stands now, an agreement has been posted publicly, right, for the public to look at, just in compliance with OML. If there are tweaks being made to the agreement, that cannot now be posted, with the changes. So I think it's cleaner to have a future agenda item with this listed with the revised agreement, as part of the packet of that.
So, all right, so,
Is it in the public facing board packet? The stipulated agreement?
I thought this was, is it?
Because
Is
if
this-
it's not, then I don't think that's germane, because I'm just trying to find it.
Might not be clear.
Madam Chair,
Yeah.
the stipulated agreements have historically been
Are they privileged?
and no, the stipulated agreement that is being considered has been historically included in the public meeting packet. There is additional information that is not in the public meeting packet that is for commissioner review only, that provides summaries, et cetera.
Okay,
Everything.
thank you.
but to that point, is April 16th, would that be
I'd
amenable?
rather do this at the sooner one, get it over, get it done with. I really think this is either a yes or no, and I'd love to get this done. I don't want to push this too far off, and I think it should be.
I'm sorry, just to clarify, April 7th.
Whatever it's, I think it's April 7th.
Okay.
Yeah.
I'd rather put it on there, but my sense is you probably can make a phone call today or tomorrow, and I think that you probably can wrap this up by then, so we're not taking too much longer. Okay, so, so what I will do is I will move to, I'm trying to think if I need a motion or I can do this. I can just table this. I will table this
What's that?
until the April 7th or tentatively scheduled April 7th meeting for final vote. Commissioner Benedict?
Given that that's the approach that we are taking, I would be inclined through Madam Chair to ask Enforcement Council whether it is clear what we are looking for. So that we aren't back in the situation. Like, for example, if we are looking for training, do we need to provide greater clarity on what that might entail? I don't want this to come back to us
No,
and
no,
say,
no, no,
that's
you're
not
absolutely-
quite what we meant.
So have you clarified, can you just restate? I've stated clearly what I would like. I would like either monthly or quarterly payments so that we don't wait until the end of the 12-month period. I think that is appropriate, and I think that, there may be general consensus here on that. And Commissioner Stebbins, I mean, oh, yes,
Apologize, could I just ask a clarifying question on that item for you? So understanding definitely monthly or quarterly payments, is there a time period? I also understand that.
I think that the
1 year
12-month time period, but I think that we should be receiving payments upfront so
Understood.
that we're not waiting until the very end. Because
Within
they
the-
could pay everything upfront next week, but that is, again, this is why time is money. Everybody would want to wait until the very end to have to pay something, and that's why we need to be very prescriptive in terms of when they're gonna have a fine, when they have to pay it. So I am not wed to monthly or quarterly, because I certainly understand that, you know,
Just some form of, during that 12-month period, there needs to be some progress towards fulfilling the
yes,
payment.
yeah, no less than quarterly.
Yep, understood.
Okay, I don't know if anybody else.
I agree with that.
Commissioner Stebbins?
Just so I'm conveying what I want enforcement counsel to hear is I'm comfortable with everything else in the stipulated agreement, but as it's been discussed, the payment schedule. So that's the only outstanding issue for me.
Okay, so I think that I have the authority to table this until the tentatively scheduled April 7th.
Madam
meeting.
Chair, excuse me, sorry, just to clarify too, on the training component as well, we're looking for youth prevention, diversion as the two kind of subject areas, also noting too that or recommending or proposing here as well that paragraph or obligation may take the form very similar to the ethics training course that is identified here, where we would put the onus on the licensee to identify an appropriate opportunity. Again, we're kind of working with the tools that we have for responsible vendor trainers, but absolutely making sure that this is more tailored. We have
Because everybody has to do responsible vendor training and apparently it's not working. Right?
understood
And it's all about age gating.
having tailored.
All about age gating and it didn't work here. So that's why I think that it is appropriate that there be a little bit more drilling down. Sorry, that's another 4 hours out of your life you'll never get back, but it obviously didn't work the first time. So I want to make sure we focus on this. Okay. Mr. Stebbins?
If we are adding the training component to it, I would suggest it's not the RVT piece, and we talked about the resources that are available. If we're going to add something about the training piece, I think it should be perhaps somebody from our team doing instruction as to regulatory compliance. I mean, even when you look at the ethics training requirement, you're still looking at having to review the credentials of the person that they want to go out and get. I don't necessarily want to put that burden on you if the training resource is somebody we might already have in-house.
Yeah, but that's the only thing I'm a little bit, well,
So I mean,
I'm sorry, what you said?
if we're saying we need a new expectation around training and the RVT, including making everybody go back through RVT, and some of their agents might have just gone through this, you know, the training piece, instead of having to go out and procure a individual who then we have to go through the process of looking at whatever curriculum they want to do, if it's just our team talking to them and saying, here are the guidelines and the regulations you need to be aware of so this doesn't happen again, I'd be more in favor of looking at that than saying you got to go find an external trainer to try to do this work. I mean, we get a lot of our training from in-house, state, other agencies and departments is probably higher. But
Commissioner Roy?
Not comfortable with that because there are groups that specialize in youth prevention. Like, yes, we care about it. We don't specialize it. And so I just feel that the training should fit the infractions more appropriately. We all agree RVT didn't, obviously the messaging didn't get through, right? So
Maybe our staff can help identify.
Staff has to approve.
we have to
Yeah,
approve
Right,
it.
so if that works, then I think, does that bridge?
I'm just concerned, but the other thing is, and this is, and I don't know if he's like hiding from me back there, but
Actually, if I may, another thing is that we want to put a time frame on when they have to find these trainings, right? We can't, so within 30 days, identify. I think the ethics had.
Madam Chair, just to respond to Commissioner Roy, so currently as the agreement is, it's during that probationary period, the licensee, Mr. Daly, have a 1-year probationary period, which takes effect no later than 20 days after ratification, subject to approval of a short-term operational plan. So this would still fall within that, within 1 year from ratification, these, the ethics training and any other additional trainings that are subject in this stipulated agreement would have to be completed and verified.
Chief of Investigations and Enforcement. I would almost like any thoughts that you have, and this is also one of the things that, you know, I hope that you and I can, you know, work together is, you know, maybe we as a commission, I think that there are a couple of different things. We probably need to do more, and you've begun this, but more training around testing fraud, more training around other compliance issues. So, you know, this may also be something that we host for all licensees. Because again, we've talked about different NODs, what, you know, there might be some sub-training there, but I agree with Commissioner Roy. I just want to make sure that we're not putting too much on you, and you're wearing multiple hats, and we know that. So we just love your take on that, if you don't mind. How, you know, just your take on Commissioner Stevens's proposal.
Oh, absolutely, Madam Chair. Thank you very much. So I think it's an interesting approach. What I would just want to say to my co-CIE and Enforcement Counsel's previous comments, again, stipulated agreements, investigations, you're going to be looking at, again, case-by-case specifics. So I totally hear the points about the need for some kind of general, again, training. Again, I know we've had previous discussions about, you know, commonly cited violations. So I certainly think there's a space there. But to Commissioner Roy's previous point about, you know, certain RBT vendors, again, they are the subject matter experts in these areas. So I would be a little hesitant to say across the board it's something we can entertain. But just to kind of clarify kind of the board expectation and what the board would like to see for this specific case.
Right.
If the question is there an aspect about this particular matter and the training requirements that are going to be imposed that we could work with the licensees on? That's something we can
I
surely.
think that the staff has already expended a great deal of time, effort, and resources on just this one case, and so
Agreed.
that is, you know, my concern up there too. So, all right, so Commissioner Stebbins, and then maybe Commissioner Roy, you know, I mean, can the two of you talk amongst yourselves? I mean, how do we kind of get to where we need to be?
I
Where
mean,
you're comfortable? I mean, I think we're trying to get at the same thing, but I just want to make sure that we do it with the least amount of friction, with the best amount of education. I think that the licensee, you know, understands, but how do we do it so that we are setting a standard that is going to be replicated? Because while we treat every case individually, we need to be equitable, and we need to make sure we're setting standards that are repeated. So Commissioner Stebbins?
sure. Thank you, Chair, and thank you, Director, for your input. I think where I'm trying to come down on is, to the chair's point, less follow-up work for all of you to have to do. What's in the stipulated agreement are violations of our regulations. I think training people on what those violations were and why their employer is in trouble are important facts. And those we can all speak to, right? You know, you violated XYZ. Let us explain what this is. You're accused of violating this regulation. This is what it's all about. And I hear my colleague talking about youth prevention. We have regs that are designed to prevent youth access. It didn't work, but to go out and think that we need to find an experienced trainer in that, when again, it comes back to violations of regulations. I think our team is more appropriate to speak to those points than anyone else.
You're right.
Director Enos, co-CIE, how many hats do you wear right now? Can you tell me?
Technically 4, but one will be coming off
What are
very
the four?
shortly.
What are the 4 hats?
So there's the co-CIE, there's the Director of Enforcement Training. The hat that will be coming off soon was Director of Investigations. And then obviously assisting the testing with the Director of Testing, which we hope to fill soon with the Director of Testing Compliance. So 4
4
technically.
teams in essence report to you. How many dozens of individuals
Yes.
report to? Okay. And we have a hiring freeze. We have a budget shortfall. We're wearing many hats, testing protocols are coming down the pipe, social consumption. I can't speak for you, but I don't think you have the time to create a module on youth prevention right now. And it would be our resources and our time teaching. And when it could be the licensee's expense to hire or be part of a youth prevention, and their time and their expense versus your time and the agency's expense. Now, can both be true at once? Can we reinforce regulations? Absolutely. That's our job. But you're not an expert in youth prevention, nor should you be. And that's not fair to you. So let the licensee bring us some choices and we'll approve. And we can work on reinforcement to the chair's point. I know you guys have a vision where you want to go out and talk about NODs, and that makes perfect sense. But in this case, the time and resources should be placed on the licensee, not you.
So are you
I
just,
can respond, Madam
oh, I
Chair.
thought it was like a really big thumbs up.
Oh, I
That's not
want to
what I'm
verbally
asking about.
give Commissioner Roy the thumbs up and thank you for that. Yes, Commissioner Roy, as you stated, we are obviously going through some, bandwidth kind of concerns right now. You are right. I am the one person in the training department right now. So I appreciate your words and thoughts there.
Great job.
Oh, I appreciate that. Thank you. Thank you. So I absolutely agree with what Commissioner Roy said. But I did just want to say to Commissioner Stebbins and the chair's points, again, I do see the space for this eventually when we kind of have more time and, ability here. And I think this kind of does tie into our previous discussion about the commonly cited violations. So we certainly can provide some kind of education to our licensees about those commonly cited violations, even those in the stipulated agreement. So those we can absolutely speak to currently with our knowledge right now. Just as Commissioner Roy stated, the bandwidth and the resources are probably the major limiting factors. So it's something that I am hopeful that we can eventually get to once things open up a little bit more. But I do kind of agree with Commissioner Roy's initial assessment of where we are right now.
So okay, because I do want to, Commissioner Benedon is right. I want to make sure we have consensus. We don't have to take, but I just want to make sure you're comfortable that,
I think both can happen.
yeah,
Yeah, and if I may.
yeah.
No, it's a good discussion, and I'm on a couple of working groups with Armand already, so I do know how stretched he is for time. I just want to make sure that we're clear to Enforcement Council about internal training, external training, whether it's RVT or we're scrapping RVT, because again, he's got to go back and talk to the licensee and bring back something. And I think to Commissioner Benedon's point, we don't want to keep going through this if he's not clear.
Maybe RVT, I mean, if you look, because that's what it's all about. It's all about age gating. So, I don't know if there's anything else out there. Let's let them look. Or if there's some way that we can even, whomever is, and this is kind of thinking out loud, but whomever is hired to do the RVT, that maybe they provide some, because I've been through it, you've seen it, you know what I mean? There may be ways that they can individually tweak something like that to understand the particular circumstances of that licensee. And it's not that hard to tweak, I would think. I mean, do you agree?
I would like to think so.
Yeah. Okay.
I think specifically for me, if we're talking about the training piece, is I'd like to see the training be less broad than making somebody go back through that 4-hour session. What we're trying to make sure is that licensees, agents are aware of, again, for me, what's violated and in the stipulated agreement. And if we want to add some topics around youth prevention, but it hopefully narrows the scope, but also, again, we want to be clear to the Enforcement Council what he needs to add in the stipulated agreement. And I would be okay with stripping out RVT, the 4-hour program, and finding something more dedicated.
So that there's a lot of it in the RVT, and if you, but you've been there. It's human beings who have a curriculum and they know this like the back of their hand. So my sense is they could probably, Executive Director?
Thank you, Madam Chair. Through you, wondering if EC could kind of summarize that his understanding, leaving the meeting with the tabling, and then if that matches, I think he should be all set.
Okay, please.
Thank you,
And
Madam.
just to let people know for timing, we're now been here a long time. We've done all the licensing. We've done sort of the, one that is thorny right now, and sort of understanding. So once we're done with this, we probably will take a lunch break to, so anyway, just want to let people know who are watching. So go ahead. Thank you.
Thank you, Madam Chair. So in essence, what I am hearing is the two adjustments or areas for adjustment in the stipulated agreement would be essentially one, to paragraph 77 to further define either monthly or quarterly payments of that fine. And then two, in paragraph 86, relative to the continuing education for all of licensees' employees, tailoring that more specifically to youth prevention and diversion.
Good. Commissioner Stebbins?
And the regulatory violations.
And the regulatory violations.
I'm okay.
Commissioner Ryan?
I just want to make sure my colleagues are okay that they could complete the training on day 365. Like, there's, to me, respectfully, I think we need to, that needs to be done within the first 60, 90 days, or like the training.
Is there consensus on that?
Agree.
Consensus on that? Okay, I agree.
To couching that within the first 3 months of the probationary period.
For the first quarter. Yeah, that's the first 2 months, yeah.
Okay, so are you comfortable that we have it?
Yeah, I
And again,
believe I have an
I
understanding of this.
understand, I appreciate the comments of Commissioner Benedon, but we don't get a lot of these. And this is also because we have not had a complete 30A process for a number of years. And so we're now really sometimes doing some of the stuff, I won't say for the first time, but almost the first time. And so I think it's new to the commissioners and especially to this group. Commissioner Roy?
Thank you, Madam Chair, and thank you to the team. Just also to be clear, I think it's April 7th you want it brought back by?
Yes.
Okay, and I just want to thank Commissioner Benedon for pushing back on executive session, because I think this was actually a healthy discussion to have in public. And actually, I think it was good for you to hear from where we were coming from, right? So you understand, it wasn't done behind closed doors. You heard it and the public heard it. So I think it was beneficial to the licensee and for all the staff, because not all the staff gets to participate in executive session. So I want to thank you for pushing back on that. And I think this was a good conversation to have in public.
Thank you, Commissioner Stebbins?
Thank you, Chair. And again, I know I've had this conversation with Enforcement Council looking for consistency expectations. I hope or would welcome, between the assured stipulated agreement, this stipulated agreement, which we hope is close to the finish line, that we're beginning to give you some comfort level with what, should one of these come up again, that you basically know at least what this 4-member board is looking for as we go forward.
And again, bringing up assured, this is always the prerogative of the commissioners. Right, Commissioner.
One last request through you to legal. Could you draft a memo if we go into the reg next time, ways we could modify this language on 507, so it's not a this or this, where we could have a little flexibility. So if you guys could give that some thought and you provide a memo to us, that I think that would be helpful too.
Okay. All right, so then I am tabling the final approval or vote on the stipulated agreement with Boston Bud Factory until the tentatively scheduled April 7th public meeting. Okay. Thank you. So it is 12:15. Are people comfortable coming back? Because I sometimes always give us too little time for lunch and sometimes people have to still find it. So I will entertain a motion to recess until 1 o'clock. Commissioner Roy, do I hear that motion? Commissioner Stebbins, do you second that motion? Having been moved and seconded, I'll call the roll. All those people in favor say aye, all opposed? Got it. Thank you. Thank you again. Okay. All right. Thank you very much. Returning to the agenda, as I stated earlier, we will be tabling the exit interviews overview that Chief People Officer Deborah Hilton Creek was going to present. I will be taking one item out of order because it then will flow with other conversations that we'll be having. So the first item that we will have under commission discussion is discussion and update on addressing testing fraud. First of all, I want to acknowledge Commissioner Roy for having really pushed hard to make sure that we have more transparent data on our website. She just off camera was congratulating our Chief Technology and Innovation Officer for making that a reality. People are looking, they're finding meaningful data, and I have gotten a lot of positive feedback. And thanks to the Executive Director for working with Paul to make this a reality, and everybody else on the team that I am forgetting. And that's why I hate calling people out, because then I forget some of the people who may also. But I think that this is an important opportunity for us as commissioners. And I know that everybody has been doing a lot of tours and speaking with a lot of stakeholders. We know that there are at least 30 licensees that are in receivership. We heard anecdotal information that there could be another 30 facing receivership. I did a tour at one high caliber licensee down on the South Coast. And I was told that they've gone from 200 employees to 140 employees. And the only reason that they're able to maintain their business is because they, have multiple operations where they can maintain the staff that they do have. I've talked to other people who have said to me, I do not know how much longer I can keep my business open if I have to compete with cheaters. I was given one example yesterday by someone who has taken a look at some of this data, who told me, I'm selling, certain product at, $18 a package, and my competitor is selling them for $4 or $5. The information that is out there shows what our Chief of Research, Julie Johnson, tried to put forth 2 years ago and was discouraged from preventing that information because it could be negatively perceived about the commission's reputation. And this is one of the important steps that we need to be taking as a board, as a commission, is to understand that when there are problems that we see, we have to look at them, we have to name them, we have to acknowledge where the shortfalls are, and then we have to have a plan to address that. We know that the problem of inversion is something that is still being fully reviewed. We know that diversion is a problem. We have had recent information about product being brought in from out of state. We've heard issues about inversion where spiked gallons or barrels of ethanol are brought in that result in high THC products, the likes of which defy science. We know that sometimes we are seeing significant and disparate pricing of products that are in the market. And so this is why looking at testing fraud is really important to me. It's why it's really important that the commission, again, 2 of us were not here when the commission voted to hold, at that point in time, the largest independent testing lab in terms of business share held accountable. But we aren't done. And we need to send a really strong message looking at the publicly available data. I do want to congratulate our co-CIEs for the work that they did to examine, to investigate, to look at testing fraud, and the first case where we had a $300,000 penalty. But everything I'm hearing is that our job is not done. And so I raised that today because, and I don't know if my fellow commissioners, but We need to put even more data, and this is something that I know Paul is working on. We need to be analyzing yields because that's where we will see, again, inversion of product that has not been properly subjected to our regulatory standard. We need to develop an SOP to test ethanol. We need, and we will be looking at testing protocols, and I want to thank the team. I want to thank the executive director and the team that has been internally working on making changes to testing protocol because this is sorely needed. So again, I just want to thank the team that's been working on this. I want to thank the outside stakeholders who have given us their personal stories about why what we're doing is critically important. We have an industry that is in crisis. We have heard so many stories from so many different persons that are barely hanging on, and they say, I'm barely hanging on because I can't compete against cheaters. And so the message that I've been saying is that that is my primary goal over the next several months, is making sure that the people who are playing by the rules, the businesses who are following the regulations and statutes, that you don't have to compete against cheaters, and making sure that we both can say testing fraud in public, but that we understand that we have the tools to address it. And again, I want to thank the people who made this public. I want to thank the people who've done some of the analysis. And again, I want to thank Dr. Julie Johnson, who attempted to raise the flag about this 2 years ago, who was discouraged from doing it because it might make the agency look bad. So again, I don't know if any of my other fellow colleagues want to talk about that, but we have had some meetings this week. We have been getting 2 by 2. We've been getting 2 by 2. Hold on one second.
I didn't want to send that.
That's okay.
I had a trigger finger with the
Well,
enter key.
I want to thank everybody who's been working on the testing protocol internal working group. They've been at it for a long time. We've been having 2 by 2 meetings again, just to explain. The public generally understands 2 by 2 meetings, so we are not breaking quorum to understand the high level explanation from our staff about what they're proposing to make improvements here. And so with that, I don't know if anybody else has any comments or questions, but we will be bringing that forward in the coming weeks. And Commissioner Roy, I don't know if you have anything you wanted to add.
So I just shared a little early some motion language. I too want to echo your sentiments that a lot of licensees are struggling right now, and they are on fumes, and they can't compete with cheaters. And again, this isn't unique to Massachusetts. This is a nationwide problem in the cannabis industry and the regulated industry. I do want to thank and acknowledge the testing task force team, as you did. They've done incredible work, as we saw with Assured, and they moved expeditiously. Testing fraud has multiple impacts. It is consumer fraud. If it's THC related and the potency is not accurate and it's over 30 and maybe it's somewhere around 20 and they're charging more for an item. And so that's consumer fraud. And secondly, you know, when it comes to total yeast and mold, in the Assured case, we had arsenic was passed, heavy metals. That goes directly to public health. And there are a lot of patients that turn to cannabis for medicine, and many of them are immunocompromised. So we all took an oath, and you know we need to uphold those pillars of public health and public safety. So I'm grateful to the testing task force. It was explained to me that it was temporary, and
What's temporary?
it was explained to me when the task force was stood up, it was temporary. And sitting in the public health seat and seeing the great work that the task force has done, it cannot be temporary. It needs to be permanent and ongoing. And so I have motion language, and if I may read,
Please.
that speaks to this. And I want to thank the executive director because he worked with me on this as well. Move that the commission direct the executive director to take necessary steps to establish the testing task force as a standing permanent body of the commission. The permanent testing task force force shall include the chief of research or their delegee and the director of data analytics or their delegee as members, in addition to its existing composition. Further, the testing task force shall expand its scope to include an examination of cannabis testing yields, including but not limited to dry, wet, weight, for the purpose of identifying and addressing potential instances of fraud. Additionally, the testing task force shall develop and present to the commission within 60 days a standard operating procedure, SOP, to initiate testing of ethanol for the purpose of detecting inversion or other related anomalies. Thank you.
Thank you. I don't know if anybody has any comments or questions. I'd be interested to hear, also what you're hearing from licensees. Commissioner Stebbins.
Thank you, Chair, and thank you, Commissioner Roy. I echo a lot of what both of you said. Had conversations with labs. I know Commissioner Roy was part of the working group that met through all of last year. And that was, I think, a great reaction and collaboration on our part with the testing labs. Some of those meetings got contentious at times, but I think that was helpful in trying to work through some of the solutions that are coming forward to us, hopefully in the near future. One thing I keep hearing, and I know our staff has brought it up a couple of times, is, the generous amount of data that's available through Metrc. And if you haven't had a chance to visit with our CTIO and Dr. Sarkis to understand the new capabilities with respect to the it's not a platform, but Snowflake to help us get data faster. I'd encourage you to kind of take that opportunity to get a little more background on it. But I do want to come back, and Commissioner Roy talked about some of our budget limitations. So hopefully some of those will be lifted this fiscal year. But certainly encourage us and the executive director and the team to think about what we hear other jurisdictions do, which is hiring an investigative agent who's really a desktop investigator living in it. We've all heard about it. We should be able to track, lab shopping by watching where the product goes. Things about yields to understand, what might be being added to a product. So again, just for kind of discussion as this task force continues to do its work, that would be a recommendation I would hope we would consider as the task force does their work.
Executive Director.
Thank you, Madam Chair, and to the commissioners on this. I do think, as Commissioner Roy mentioned, looking and working through this, I think this is a good direction to go. I think when we get into organization-wide goals later, talking about prioritization, I think the thing that has been highlighted through this is ideally, and we talked about working groups on social consumption, for example, earlier. We have a lot of people assigned to a lot of things. So in terms of prioritization, I think this is important. I think to the point of making it standing is important as well. I think the potential in the future as we, resolve some of our budget issues or reallocate resources towards this, to have a dedicated staff member for this so that while all of the other members who contribute across multiple divisions, there is somebody, who is assigned specifically to that task, whether that be an analyst, a data analyst, as was referenced, and we do see in other jurisdictions. I also think where we started, and I appreciate the credit provided to the I&E team from the chair's introductory comments. To get this going has been significant, and to maintain it is also going to be significant. So I think some of what will make this sustainable is going to be building in consistent queries into Snowflake that can be run on a consistent basis that are not going to take additional people hours, but that can be done consistently. And then the team, the task force could then have the benefit of that and a dedicated person in the long run. I would agree with, obviously in the short term, we can't commit to that at the moment, but certainly go that direction. So I would say, going the direction of formalizing, ensuring that we have, the team members there and that they have the authorization and prioritization to focus on these things in addition to their normal duties, are things that I think are all great, and I look forward to working on that with the commission.
I will point out that in looking at some of the data that was turned into, sort of very compelling graphics I think it's pretty easy to see that one, the temporary suspension of Assured's ability to do business did not go across all testing labs. And this is where I think that we have some outside qualified data scientists who can provide information to our investigations and enforcement team that should provide us guidance. One of the other comments that we did have when we were going back and forth about testing protocol, about, you know, the share of the market and whether that, you know, I also think that I've gotten background information that the testing labs that appear to be struggling, that are chasing business from a small group that seem to, for some reason, have the bulk of the business. It sounds like they are cutting their prices to be competitive. And so it would be an interesting data point to determine what is it that's driving people to a small handful of ITLs, especially when competitors are lowering their prices. And you know, we should not allow people to pay for results. We should make sure that the data that we see, given the new, you know, open data process that we have on our website, this should be a red flag that our team begins to look at immediately. And again, I'm just looking at data like everyone else is, but it's pretty easy to see what happened in August. And that would be my concern that I raised with the executive director, that everyone take a look at that data. Again, a lot of this data was exposed to us by Dr. Johnson a couple of years ago. So I think that the data is there. I think that the data is something that we need to analyze, but I think that we cannot wait months to jump on that. And I think that it is an immediate crisis, both within the testing lab accountability system, but when you hear from retailers and manufacturers, and again, it's more sides of the coin here. It's obviously people on the other side who are making these choices to pick the ITLs that perhaps might be providing THC levels that are completely beyond any normal bell curve. Those people have to be held accountable too. So I hope that we can, within a matter of weeks, get an understanding that our staff will be looking at this data, and maybe not talking about individual licensees, because we do have 30A, but we need to get I think a strong commitment that that data is going to be used, that there will be investigations begun immediately to answer some of those questions. And a lot of the questions can be solved in the data. You can not only see where the potential incentives are within the testing world, and you also will be able to, by looking at the analysis of yields and the SOPs looking at ethanol testing, you also can see who on the other side of the coin may not be following the laws. So anyway, I don't know if anybody else has any comments or questions at this time. Commissioner Roy?
Thank you, Madam Chair, and I thank you for your support on this and for your leadership on this. And again, to go to the work of the data task force, I mean the testing task force, is that the failure rate for sure was 0.9% failure rate prior to enforcement. After the fraud was identified, the failure rate went to 27.2%. And that's a testament to their work.
Exactly. So I think they're giving each other a high five back there. So I don't know, but anyway, they should be. Commissioner Wright.
So on the protocols that we've had our 2x2s, you and I have not finished. We got through half with the team, and I'm gonna blame I'm fully self-aware. I'll blame me.
No, I'm the queen of the dumb questions.
No, I asked.
You're the queen of the smart questions.
So, so based on where we are in this moment of time, and I believe Commissioner Stebbins and Commissioner Benedon, you had your 2x2s to go over the recommendation, and we're half done. And so I think next week, Abby and Kate are working to get that on for us next week. So I worked with Commissioner Benedon on some motion language about next steps, and not getting into any policy and not getting into any deliberations about what was in the recommendations. This is just forward looking. So I'm going to share some motion language. If you can just give me 30 seconds, Madam Chair. I don't know if there's anything else anybody want to sing or dance while I do this. I just need about 30 seconds to.
Any more opening day stories? The head director, would you like to share? No.
Not an opening day story, but actually, I'll wait for Commissioner Roy.
No. Oh, okay. I need, if I may, can we have like,
You to, I'm just trying to see if there's, I don't know if there's anything else that you would like to, while she's typing, update us on at this point in time. By the way, you know, you could do we know if April 7th is agreeable to everyone's schedule for another meeting in April? I know that you have some.
I would need to leave by like 3:15.
Yes, yeah. This is just giving us one, because we just have so many different moving parts right now and a number of different regulatory groups. So yes, so we will make sure that happens.
Staff can make that work.
They can. All right. So that's, and Commissioner Stebbins, are you okay with that date? Yeah.
okay, I think I fixed, I took care of that. Okay. Ready? There it goes. All right, if I may,
Please, Commissioner Wright.
again, this is regarding the proposed testing recommendations, which will ultimately revise the current protocols and to a degree, the regulations. So the motion reads, move that within 2 weeks of today's date, March 26, 2026, the commission lift deliberative privilege on the document titled, quote, recommendations for consideration, testing of marijuana and marijuana products protocol, and any associated memoranda containing the recommendations concerning independent testing laboratories and the testing of marijuana and marijuana products protocol once the conditions below are satisfied. Prior to lifting privilege, number 1, commission staff shall complete 2x2 meetings with each commissioner regarding the recommendations contained in the testing document. Number 2, commission staff shall incorporate into the document any edits and direction provided by commissioners during those meetings and shall prepare a revised version of the recommendations. Number 3, upon certification by the executive director that these steps have been completed, deliberative privilege on the revised testing recommendations document shall be deemed lifted. And number 4, the revised recommendations shall be transmitted by commission staff to all licensed independent testing laboratories, ITLs, as well as posted for public review. Number 5, ITLs shall be afforded a period of 2 weeks from the date of transmittal to review the recommendations and submit written comments and recommendations to the commission. No vote of the commission to adopt, modify, or reject any of the recommendations contained in the testing document shall occur until after the expiration of the 2-week ITL comment period and after staff have compiled and presented ITL feedback to the commission. Thank you. And I want to thank the executive director and Commissioner Benedon for their help on this.
Executive Director.
Thank you, Madam Chair. And I had reference to Commissioner Roy. The one question I have, just so there would be clarity here, is on number 2. So I just, as an example, I can't work with all of you on, let's say I got feedback, the testing team got feedback on one of the protocols that was not in agreement from different commissioners. I can't workshop that and then bring it back the way this is written. So that's my only concern, of just setting expectation.
What do you mean by workshop? I'm not sure what you mean.
Like, the biggest issue is, we can't give you all a Google document and say, here, add your comments and thoughts to it, because it's an open meeting law issue. But if you're saying, we'll give you the comments and we can incorporate it, my only concern is if I get conflicting feedback from commissioners in different 2x2s, I can't really, outside of public meeting.
You can't synthesize.
Resolve that, right?
Yeah.
So the word that shall incorporate into the document is just, I would need a little bit just to talk through kind of how that would look.
Can you incorporate it in two different color inks? I mean, when you have a competing proposal, you just, I think that that's easy enough for us to be able.
If I may,
Commissioner Rye.
and once you have our feedback and it's synthesized in that document, don't give it to us until the day you release it, then it's public. So then we wouldn't violate OML. See, like what, so you get all of our feedback and you incorporate it on maybe a separate document or whatever. If we get it the same day that the public gets it, there's no violation.
So I guess my only, if I could just talk that through.
Commissioner Bennett may have a.
I was just going to suggest another approach, given that it would be right about the 2-week period, is that we could require commissioners to provide their input prior to April 7th. And to the extent that there is any conflict, I recommend one thing and Commissioner Roy recommends something else. We could talk that through at the April 7th meeting, but we happen to have that.
Yeah, we could talk through in public.
Yes, from now.
I'm okay with that. Yeah.
That gives us only like 12 days to submit our comments rather than 2 weeks, but I feel like we could do that.
I agree.
Commissioner Stebbins.
And I'd feel more comfortable about that way we have a chance to talk about it in public meeting before it does get distributed to the ITLs. So
No. Am I misunderstanding?
I think based on your wording, if I may, Madam Chair, I think based on the wording, you wanted it in this consecutive order, you wanted the commissioner in there before it goes to ITLs. And so I think it all, sequencing standpoint, it does.
We've gotten the first, but we're getting the first version, but we would like the input of the ITLs.
Right, so the sequencing here is you finish your 2x2s, you provide feedback. And then after that feedback is incorporated by the executive director, it's then going to the ITLs. So I think to Commissioner Stebbins' point, if you're talking about what's being incorporated in public meeting prior to it going to the ITLs, then it would be after the April 7th meeting, the sequencing was. I think that's his point.
Are you talking about you want to get input from the ITLs before you provide your commentary and feedback? Yes, I'm asking.
Yeah, I think it would be enormously, I have provided commentary and feedback on our
Right.
2x2s and we did. And so I would prefer to, what's the date 2 weeks from today fall on? Do we know? The 9th. And our next meeting's the 7th. So I didn't mean to cut you off, but you're proposing that we talk about it on the 7th? Is that what you were thinking?
For me, and I obviously our goal here is to get something out. We do want ITL feedback on that. I guess I'm wondering if we had a meeting where I think it'd also be helpful for our testing team to kind of walk through the protocols. Yes, we've heard about it in the 2x2s, but for them to walk through it, hopefully our ITLs will listen and kind of take the protocol recommendations or the protocol changes in that context and understand where our team is coming at with respect to any changes, and doing it first in public would also give us the opportunity to hash out any differences that we don't want to settle the ED to have to do. But
At what point do you want to get input from ITL?
Yeah, that's what I'm struggling with. So
With you, because
like I said to Commissioner Bennett yesterday, I'm not a microbiologist. Nobody on this board is a microbiologist. And I would like, it's going to color my recommendations. It's going to color my thinking. And I need, like, I've been at testing for a long time and I'm a lead on this. And this was a commitment we made to them too. It was like, and so I would like to hear from them, give it to them, and we could get it. And I just
you
feel
want
like,
to be able to give it to them what we have in writing,
yeah.
rather than just talking about it. See, this was also because a lot of what we heard is very high level. And so what, how is your motion, how is executive director, how is her motion not getting what she wants? At what point, what is the sequencing here? Because if you want to get input, I think what you're saying is lifting the privilege. So this is no longer a privileged document. Again, I think we have to have this be made public, because otherwise we're asking them after the fact. And then
I'll give you an
we might be
example.
hearing
May I
information.
give you an example? I'm sorry.
Right.
in the 2x2s, I can talk about this publicly. I advocated for a broader panel on pesticides. We only test for 9. We test for a very limited panel. Some jurisdictions test for over 300. And I want to hear from experts in pesticides before we land on a spot on pesticides. I'm going to advocate we need to test for, and, you know, I know we talked about parts per billion, right? I'm hearing that 10 parts per billion can give false positives. Okay, and so perhaps we need to go to 100 parts per billion because it's too sensitive and and that exposes us. Imagine if we say you violated it and they didn't because it's too sensitive. So,
And I am hearing that the standard is technically really supposed to be 20,000. And we are using the 10,000 CFUs.
right,
And again, that is just past practice that we followed,
right,
but not necessarily what is embedded in our regulations. And so that was news to me.
right.
So this is the false positives that again, I'm given anecdotal information, and that it's anecdotal, that 13% of some of the fails never should have failed. And that's real money to businesses that are struggling. And again, while on the one side, we want to make sure that we have the utmost health and safety in protecting the public, we also don't want to have something so overly sensitive that it's harming businesses as well. Commissioner Stebbins.
Sure. And I think our goal is both the same.
Yeah.
We do want ITL input. Everything we've ever done, we've always had a period of time where folks can offer their input, whether it's through, public comment on regulations or what have you. And yes, nobody up here has a chemistry degree or epidemiology, but I would welcome the opportunity for us to, and I think, again, takes the quandary away from the ED, talk about the protocols, the draft protocols in a public session, allow us to kind of, work through any differences we might have in language. And I think at the same time, give our testing team the chance to walk through it again, not just for our benefit, but also for the ITLs that'll certainly be watching that meeting. And then we put it out for that public feedback. So I'm just saying. It might be. I don't think it's anything inconsistent with what.
Well, the executive director.
If I may, I think the only issue here is we probably want to just separate it, because the sequencing right now, I think, is what's blocking everybody from getting kind of what I think everybody agrees to, which is you want ITL input and the commissioners need to finish and provide their feedback, but then also have the opportunity to then take the feedback from the ITLs or anybody else that would review this when it's posted publicly. So if we separate those two timelines, right, we need the commissioners to finish, then and we want the ITLs to and the general public to be able to review and provide their feedback for you all to have and the testing team to have. I don't know that we need to sequence it this way, and that might avoid the issue of if the version is considered draft, because it's not final until adopted by the commissioners. We could simply, note that it is a draft and provide it. I think the removing of the privilege, I think there's probably a couple of tweaks that need to be made to remove direct references that we don't own, but by referencing USP and ISO, we can, make that publicly available easily. And so I think if we get the version out to ITLs while you are still reviewing, and then you also are then getting the ITL review.
All right, so I just want to make sure you're comfortable, because I'm more comfortable giving my input with expertise at my side. So I'm just saying, I'm going to give my input, then it's going to go out, and then I'm going to get the expertise at my side. So that's why I see this as somewhat, but maybe we want to take more time. We want to take more time. Okay,
You got it.
Oh, okay. What am I
Just
missing?
note as well, I mean, this is not, anybody outside listening saying, oh, this is not what I expected. I mean, this was discussed by the board, the intention to get this out for ITLs and the public to review so that you all have that feedback. So I think that would be consistent. I think we have to make a couple small tweaks to make the document available from the USP ISO kind of perspective. But I think if we did that, you're still going to be making your recommendations as commissioners, because you're the ones that are going to be reviewing this in the end. So if you want that feedback, I'm just separating the timelines so that they're not, like, they're concurrent.
Concurrent. Madam Chair,
Commissioner,
I personally, I need that feedback before I can give my full input publicly. I'm not comfortable doing it without it.
I, I tend to agree with you. Because that's why I feel it's an extra step unless we, I mean, again, we could take more time on this, but remember, we were supposed to have this first, and this is not critical, everyone's wearing 5 hats, but we were supposed to have this first version in the end of December. And now it's March. So I just want to make sure that we're not taking too much time. Commissioner Rudd.
Can you walk us through how they run concurrently so everybody's on the same page?
Yeah.
You said.
Certainly. Madam Chair.
How do we release this? How do we waive privilege? So this does become public concurrently while we are looking at it and still getting the feedback from.
I think there's a couple items I don't know that need to be addressed within the current document that you have to make it more publicly available, referencing the ISO and USP as the examples. That I think we could do relatively quickly and have this available, ideally, certainly within the 2-week period that's in here, maybe earlier than that. Get that out, promote it so that people know that it's available on the website, and ask for a timeline to turn around comments to the board by X date. I think the 16th we had previously discussed as kind of a timeline to allow the commissioners time, but it may be if we're going to have 2 meetings or 3 meetings in April that you want to, this may be a multiple meeting discussion, quite frankly.
Oh, yeah.
So, obviously you need to give them time as well. So if you give us a period of time to make this a publicly available document, and then give us the timeline that you are asking the public and the ITLs to turn around their comments, then we can build that. And then at the same point, you're going through with the testing team initially prior to having those comments, and then you can then review as well with that feedback.
I think that's helpful.
So, do you want me to start singing as you
Yes. So I'll work with the executive director on edits on that.
take me up to the bog? So where do you want to go?
Okay, we're just about there, Madam Chair.
Please, it's okay. Just.
Okay, this was to everybody. Um. Which is in there. Yeah, I got it.
Are we talking already? Yeah. All right. What needs to.
No, I was just giving you an example.
Oh,
So-
but we don't need to see now. Oh, okay. Okay. It's much shorter, on a good note, it's a much shorter motion, motion language. Okay, thank you, Mr. Executive Director. Move that within 5 business days, the commission provide a publicly available document titled Recommendations for Consideration, Testing of Marijuana and Marijuana Products Protocol, and any associated publicly available memoranda containing the recommendations concerning independent testing laboratories and the testing of marijuana and marijuana products protocol, once the conditions below are, we don't need that language, right?
Yeah.
Okay, protocol, period. ITLs shall be afforded a period of 2 weeks from the date of transmittal to review the recommendations and submit written comments and recommendations to the commission. No vote of the commission to adopt, modify, or reject any of the recommendations contained in the testing document shall occur until after the expiration of the 2-week ITL comment period and after staff have compiled and presented ITL feedback to the commission.
Okay,
You good with
that's
that?
good. Everyone's comfortable with that?
Yeah, everybody
Seems like
good?
it's,
Okay, thank
taking
you.
into account what you think you need.
So moved.
All right, do I hear a second? Commissioner Stebbins, do you second that motion?
Second.
Having been moved and seconded, I will call the roll. Commissioner Bennett,
Aye.
Commissioner Roy.
Aye.
Commissioner Stebbins.
Aye.
Chair votes aye. It passes.
Thank you, everyone.
unanimously. Okay, are there any other comments, I mean, about testing? There's nothing else you need to, you're good, there's nothing else you need, right? We've got this, you good?
Yes, I do actually have a question. At some point, we're going to pivot to formal rules making because it will impact regulation. So we got to keep that in mind too, right? Even though we received 14 recommendations, and the majority were protocol, but that's subject to change. More of it could end up in regulation, so we don't know. So at some point, there will be also formal rules making process.
So I'm gonna be getting to red tape removal and regulatory timeframes, so maybe we can have that conversation a little bit later in the meeting, because I think we need to kind of get some consensus about how we're gonna approach different things. Again, we just appointed another subgroup under the red tape removal committee. So anyway, why don't we stay on this vein? I think that we've accomplished what I think we all need to get the ball rolling to look at testing protocols. I think we've raised the issue. I think that we've communicated strongly to staff in terms of what we want the group to keep doing, to be looking at the publicly available data. And I will make a request to people outside that as this information comes online, we do appreciate your background and your scientific analysis. I know that more data is going to be coming out soon.
I just put the motion language together for our paralegal and our secretary, whoever needs it, because we kind of piecemealed it in the chat. So there it's all together.
All right, thank you. All right, so if we're good on that, on number 7, all right. All right, why don't we take the next one and then we can take a short, need breaks right now? Okay, all right, so would you like to take a short,
Quick.
break? Could we, could we come back at 2 o'clock? Right? A motion has been made by Commissioner Royce, seconded by
Second.
Commissioner Stebbins. All those in favor, aye, aye. We are going on a short break until 2 o'clock.
Very grateful.
Right, we are back. So now we're moving on to the search for Chief of Investigations and Enforcement and Director of Testing Compliance. And I don't know if the Executive Director feels comfortable just talking to us about the status right now, or if Chief Debbie Hilton Creek will be just updating us on the process. To just let my fellow commissioners know, Commissioner Roy is on the team that is vetting the testing, Director of Testing, and then Commissioners Roy and Benedon are going to be vetting with the review panel the Chief Investigations and Enforcement position. And then the Executive Director and I will be reviewing and finalizing those choices.
If I may, Madam Chair, and if there are any questions, obviously CPO is, if we could go to the next slide, I think it just demonstrates the current timeline expectations, which is that interviews for the Director of Testing Compliance are looking to start around April 1st and the CIE around April 10th. And so a lot of great work, a lot of great interest. And so we're excited to get these processes going, obviously very significant. And I think if there's any questions, obviously the CPO is available.
Thank you. So if CPO Hilton Creek, can you just sort of explain? And we've had, you know, and we've had some searches that have not gone according to the book, which, you know, have created, in my mind, some issues in terms of whether or not we ended up with the best candidate or the choice of the commissioners, things like that. So the first question I have is, who determines who gets a phone screen? Because I mean, I am getting, you know, some people saying I submitted, I'm not, you know what I mean? Who makes the determination as to who gets that sort of initial phone screen?
Generally, the hiring manager will make that decision. I'm sorry, good afternoon.
Oh, no, it's that.
Commissioner,
Debbie. Grab a mic.
It's not, oh,
And everybody else.
okay.
Thanks.
So generally, the hiring manager makes the decision who gets to be phone screened.
And
Oh, is it my?
is that me? Oh, so for instance, so for the Chief of Investigations and Enforcement, you know, we're talking about chief positions and top positions. So for the Chief of Investigations and Enforcement, you know, because I have seen in the past, you know, not necessarily, you know, one of the things I just want to make sure is that commissioners do have a voice in this. We've seen in the past where commissioners did not. You know, as you know, under the statute, you know, the one person that is the sole discretion of the executive director is the CFAO. It's a little bit, you know, based on our statute, a little bit more, you know, a little bit more squishy when it comes to the additional positions. But anyway, so like for the Chief of Investigations and Enforcement, who is making the determination as to who gets the initial screens?
The executive director is considered the hiring manager,
Mhm.
and the executive director is the final decision maker regarding who gets phone screened.
Okay. So I don't know if anybody else has any questions. So how are we communicating?
Commissioner Ben.
Oh, Commissioner Bennett, sorry.
I just wanted to add, because I'm one of the commissioners involved in that hire, I want to thank the executive director and our chief people officer. They did specifically give me the opportunity to review all of the resumes, which I did. It was a lot. That was a big pool, 126. And I will add that I identified a couple of candidates in addition to the 12 they had identified that I requested. So I think there was that opportunity. I would say for the most part, ones I looked at where I was like, oh, this person looks good, they were on their list, but I did have the opportunity to suggest additional people. So there was that later.
Thank you. And so you're satisfied that you've been able to have that?
Yes.
Great, thank
Madam
you.
Chair.
Commissioner Roy?
Thank you. So I think I was a late addition to the process, and I just received them yesterday morning at 9:40 a.m. day before meeting. So obviously I have not looked at one. So how does that impact the timeline to give me a little space to, I got them yesterday morning at 9 a.m.
It does impact it, but it's not a huge difference, in terms of the days. So Commissioner Ray, you've been a member of our interview team for many interviews of several different candidates, and we will have you take a couple days.
I just need a
If
couple.
you need an extended.
Just need a couple of days.
Let us know. We'll build it into the
Yeah.
plan.
Okay, thank you.
Okay, thank you. Again, I don't know if anybody has, any questions, Commissioner Stebbins?
Sure, thank you. And thanks CPO. And just for everybody's clarification, because they're looking at this, you have the same number of phone screens for both positions. That's not kind of where you're capping it. It just happens to be
Right.
that way. Okay,
Exactly. That's not a ceiling. We do continue to screen the applicants as they come in. We may reach 12 when we are at 100. We may get 50 more. We'll continue to screen because there's a lot of opportunities for additional candidates that might be more remarkable than the ones we have. So we
And
don't.
is this rolling? Are we still accepting applications?
Yes, I believe it is. We're still accepting applications.
Okay,
It's a very tough position to fill, so we did not want to limit ourselves in terms of the quality of candidates that we could bring in.
and as I vocalized, the director of testing is really important. We've lost 3 directors of testing. One left in frustration because he felt could not do the job because he could not talk about testing fraud. And so I want to make sure that especially for that position, we have someone, we not only hire someone who brings the best credentials, but that there is no sort of internal pushback based on anything other than the credentials. And I want to be extremely clear that that needs to be just looking at the credentials, not looking at any sort of extraneous issues. It's really important that we do that. So just wanted to make that comment. Anybody else? I mean, I think that's a good update. If there are no, yeah.
May I make a comment?
Please.
So on the director of testing, we had one candidate who had, or employee who had left the position. And I know that we've lost like 2 in a short period of time.
Yes.
But we typically will do exit interviews with individuals as they're separating from the agency. And in neither of those cases were we aware that someone had left in frustration.
Right.
And
I will only respond by saying we also had a candidate for executive director who was the first choice, of the 4 commissioners who voted unanimously. That person has communicated and at the time did not wish to communicate publicly about their frustration with the lack of negotiation over salary. So we'll leave it at that unless you want to get back and forth, because there have been other searches that have not been, we actually had a search where one of the candidates literally did not show up for their interview. Timelines were extended beyond a particular 5 o'clock deadline. And then that person was chased. So what I'm saying, and we'll leave it at that, is that we just need to focus on the qualifications and none of the other extraneous, because there is plenty of written documentation where some of these searches were not followed to the letter of the law. We want to just make sure that every qualified candidate, regardless of their history, interacting with the commission, has a fair shake. And let's leave it at that, because I think that that'll be healthy to leave it at that.
I just one more comment.
Sure,
please.
sure. And then I'll be happy to make additional comment.
Yeah, so we have a DEIJB program, and our DEIJB initiative, I should say, and it does cover recruitment. And I am committed as CPO to make sure that we are careful in the way we with the way we select applicants, the way we select candidates, the way we interview, because if we are going to, talk the talk, We have to walk the talk. And I completely believe in our DIJB initiative. And under my responsibilities, under the purview of my responsibilities and as a CPO, I will always ensure that there is equitable review of every applicant and candidate in the way we hire,
I just want to make sure the process is equitable. When we had a candidate that was less qualified, in my mind, who walked away from an interview process. So again, rather than going back and forth, I appreciate the statement. We'll move on from there. And if we want to kind of go back and forth on some other issues, because I've received some correspondence that does not necessarily comport with some of the narrative that we have been hearing. So let's keep it right there.
Just
No,
one
no, no,
offer,
let's-
Madam Chair, just one offer for you.
Sure.
I would offer that whenever you get information that you feel might be subjective, so to speak,
Yes.
I would appreciate it if you would talk with me because some of these.
Just so you know, I have and
I
I've
am
put
not
things,
aware
I
of.
have and I've put things in writing. I've received stuff in writing that contradicted some of the conversations that you and I have had. And I can and I will actually get additional color in writing if that's what we'd like to do. What I'm saying is, I think that we're in a good place. I'm happy that we have 2 qualified commissioners doing this, but I have seen processes, not even necessarily when you were here, that were not done appropriately. I have seen persons promoted to positions who did not have the minimum qualifications to even apply. And that there were other staff who were more qualified who didn't apply for those positions, only to find that the least qualified candidate got the job. So let's leave it at there.
Chair, I understand.
Let's leave it at there
Yeah.
because this is something that I have seen, I have observed, and I will get you additional written backup of some of the concerns that I raised, and I'll share that with my fellow commissioners.
Thank
So,
you, Madam
all right.
Chair. And also just, I am of the, my background is of the military persuasion.
Mhm.
I am a by the book person. I just wanted you to know.
I agree, and I'll get you that stuff in writing, because again, I just am making the comment that based on some of the pushback that I've gotten about some of the candidates here, it has nothing to do with the qualifications of the candidates. It has to do with other issues. So that's all I'm saying, is making sure that we strictly look at the qualifications, okay?
Thank you for
Thank
bringing
you.
that to me.
Thank you, I appreciate that. All right, thanks very much. All right, let's see. So moving on, any questions or comments from my fellow commissioners? And again, I thank Commissioners Roy and Benetton for taking these are 2 of the most important positions that we can fill that will protect public health and safety and protect consumers in Massachusetts. So I appreciate the work that you're doing. Moving on, our general counsel will be bringing us an update on the petitions process.
Good afternoon. Commissioners, Chair, thank you, Chair, for recognizing me. I think we have a slide here. I just wanted to do a quick update on the petition process, some of the changes and updates that we've made since the board voted to remove the delegation to the executive director in reviewing petitions. So first offer or note is to say that we have not received any new petitions since that time. This will, we had talked about the new process previously, but wanted to update you a little further. We've developed a form, an online form for folks to fill out to submit their requests for petition review or regulation change review. And that form is ready to be posted on the Commission's website. Legal is working with both GAP and Digital to figure out the appropriate placement on the site and the landing page, and to make it very accessible and discoverable on the site, much like the minutes that I know Commissioner Millenon had mentioned earlier in the meeting. Just making that more accessible for folks and easier to access. So we're working on that. In terms of process, the process has been updated to basically, once a petition is received through the online form, it's directed to the GC, and the GC then will provide that petition immediately to the commissioners for their edification and notification, and will provide an estimated timeline for review at that time to both the commissioners and the ED. The ED then would review the petition with the chair, and the chair would determine the next steps forward in terms of placing it on an agenda and exactly when that would happen, whether that's once the legal review is complete. And then the next part of the process would be that the board would discuss that in an open meeting after the item is noticed on the agenda. And then, so that's the process we have updated and developed in response to the board action a few months ago. And once the form is fully, ready and published, the communications team will send out appropriate notice and we'll publicize the form so that folks are aware where to find it. That's the general update. I'm happy to answer any other questions that you might have.
Commissioner Roy?
To the chair, to the general counsel, thank you very much. I'm excited to see this. I'm the one that advocated to claw this back to the commissioners. Maybe we haven't gotten any because it'll be much easier when a form is online now. So that could spur some more, I don't know. But a couple of questions. We all had to take training recently on Mass Achieve and talked about colors and fonts and ADA compliance. Will this form be ADA compliant? Do you know?
We will, of course, be compliant with whatever requirements are in effect. And yes, we would be moving to do that.
Nodding, and then
We're getting a knowing nod.
an affirmative nod. And just, so I noticed the boxes. So a couple of formatting questions, maybe to Paul as well. Paul,
Sure.
maybe Paul, come on.
When's the meeting to come up?
Come on, Paul. Is this a fillable form? So I noticed this has to be filled out and signed. So I know it's a nightmare when you can't DocuSign and you have to print it out and sign. And so is it fillable? And are the boxes were kind of tiny? So we're asking basically folks to rewrite a regulation and the box was little. So I just formatting questions.
So thank you, Commissioner. So the form that was in what you have in your packet is a PDF, is actually a PDF of the web page. We're using FormStack
Okay.
for the actual form. So this is actually not the real form that people will be filling out. It was
Okay.
a PDF version of the form.
I
It was
see.
the only way to really deliver it in the packet for public consumption. Things like the colors of the boxes were just an artifact of the way the PDF
Okay.
was created. So the signature is just like in our HR, our time off form that you can fill in with your pencil or your finger or your mouse. That is the electronic signatures. You don't need DocuSign. You don't need Adobe Sign. It's just built into that form itself.
Can it be voice activated? You know what I mean? Can you use a
Dictation.
dictation?
If you've got the assistant on your computer to dictate into it, yes,
Or
the
you could
form.
use maybe your phone?
You could use your phone as well to do that, yes.
All right, thank you.
But
Yeah, no,
we are reviewing everything. There's actually a group that now meets regularly on the ADA compliance of our website. So, this is certainly part of the consideration. So what you're seeing is not 100% replica of what's really going to be launched, so.
And to my point of the boxes, so if we're asking somebody to basically suggest new regulatory language,
Yeah, I believe those are expanded to, yeah, they're
Expandable
expandable
box.
boxes. You can drag them
Perfect.
and expand the box. I'll confirm 100%,
All
but
right,
I
Thank
believe they
you.
are.
thank you.
I just want to say, I'm glad Paul came up to answer this one.
Yeah, that's sort of like IT question. Chair.
Yes, Executive Director?
Thank you, Madam Chair. And just to kind of summarize too, which is the last point the general counsel covered, I think to Commissioner Roy's point, pushing this out, may drive more interest. And so looking forward to that, I think within that messaging, I just wanted to kind of cover this as well. I think this would work with where the commissioners are. I think the messaging would essentially be the commission currently through the red tape process, which we'll talk about on the agenda later, is reviewing the regulations kind of holistically from that regard. This is another opportunity for the public or people in the industry to engage the commission when they have issues with the regs or they want to bring something to the commissioner's attention. And so I think that would essentially be sort of the premise of the push. Yes, we're reviewing everything. Here's another way to engage. And the form, obviously, that you just asked questions on the way that it works.
Commissioner Roy?
Thank you, Chair. Mr. Executive Director, there's one in the queue though, right? Because, right, could we talk about that a little bit?
Yeah, no, sure.
Please,
Thank
Executive
you.
Director.
So there was one that came about around the time that the switch was made in terms of our process. So for that one, we've established what I hope to be a small, nimble, and quick working group to review drive-throughs. There are some elements within the red tape process that kind of overlap with the drive-through concept, but ultimately it is kind of a standalone specific question. And so we've assigned staff from legal, enforcement counsel, general I&E, constituent services on that with two commissioners. I believe the chair selected Commissioner Benedon and Commissioner Stebbins to hopefully turn around, review, look at options for the drive-through, be responsive to the petition and bring that back to the board. I'm hoping, probably, the May timeline.
Commissioner Roy?
And just to that point, and I don't want to go out of scope or anything, but it's free flowing from petitions. A lot of folks and drive-throughs get confused because during COVID, we had drive up. And this is,
You clarified.
yes, and so this is drive through, like McDonald's, right? Drive through. And so it's not the same as what we allowed during COVID, which was just drive up. So I just want to flag that they're two different situations.
Thank you.
Okay. Any further questions on the petition process? Anything else? No? All right, thank you for your work. I appreciate that. And
Thank you.
Commissioner Roy, thank you for
Yeah.
bringing that to us. So now we will be moving to the rules of necessity. I will entertain a motion to waive privilege so we can discuss the memo. So moved. Do I hear a second?
Second.
All right, having been moved and seconded, I'll call the roll. Commissioner Roy,
Aye.
Commissioner Stebbins,
Aye.
Commissioner Benedon.
Aye.
Chair votes aye. We've waived privilege. So now we can have the conversation about this. So this has not been, and this is actually, this now will be added after the fact to the public documents at this point in time. So this now will be added to the public documents. Yes,
Is that a question for me?
yes,
Chair?
thank you.
Yes, now that the board has waived privilege, it will become part of the public record.
Okay, so why don't you, so my question about this is, and I think I have raised this before, I had asked in a couple of different meetings, and you had said you were not prepared to talk about it, about votes that were taken where in the moment we had 3 commissioners, there was a perceived conflict, and you were asked for an opinion as to whether or not they could vote. And we've done that. So I think that this memo may cause us to take some additional actions because I still had not received the legal, I did not receive another legal memo that I'd asked for regarding how you based your opinion to allow. Commissioner Roy in meeting had said, can I vote on this? And you said, yes. I'm not sure that that was appropriate. And I still haven't seen the memo that allowed that. And when I read this memo, it seems to contradict the previous advice that you gave. Every effort must be made to find another board or authority. The rule of necessity cannot be invoked to break a tie or out of mere convenience, which is, I think, what, the situation we were facing in at least one situation where we had a commissioner that was out on leave. We had another commissioner that had a conflict, and rather than waiting for the other commissioner to come on leave, out of convenience, we took the vote. So if you can, however you want to approach this, because I think that this memo contradicts the prior advice that you gave, that it was okay in the moment when we didn't have enough votes to pass the license or, approve a renewal. That was the advice. So, and I've never seen the first memo. So explain why this is not in conflict with your first opinion.
Well, if I may, Madam Chair, I think this probably merits an additional conversation later on down the road. I provided that memo in response to a request for it. That is what is on the agenda for today, so I'm happy to discuss the memo. If there's further conversation that you want to have relating to other topics, then that would have to be known.
Topic. It's whether or not
It's, with all due respect, the note, what's been noticed is rules of necessity, open meeting law quorum discussion, not prior votes or anything to that nature. So to the extent that you want to have discussion about
Right.
prior votes or broaden the scope, you will have to notice that appropriately.
Right, so then maybe we table this and then we can come back, but I don't agree with your opinion, because I think that I'm specifically asking you a question about previous instances where your opinion was requested about open meeting law and about quorum, and that's exactly what we're talking about here. Do you not see?
I don't see the point, Chair. No, I don't.
You don't? Why do we need this memo then?
The memo was requested and I produced it. And my understanding was that the conversation was going to be about invoking the rule of necessity going forward.
No, not going forward. It's not.
But there's nothing in the agenda item here suggesting that we'd be looking back. So
But
if you do want to have a backward-looking conversation, then I think
I asked you.
properly noticed.
I did ask you previously to provide I asked you in a meeting to provide your legal opinion as to how in prior meetings you gave advice and what you based your opinion upon. I did ask that question some time ago, did I not?
I would have to check my notes and look back and
Sure.
don't remember
Maybe
the question.
So I do think it is related. I mean, we had Boston Bud Factory stipulated agreement, and there was no youth prevention or diversion training on
That's
the
a very
agenda.
different
And
scenario.
we talked about it, and so it's, as Commissioner Bennett once said, sometimes it's free flowing from a conversation. So I think we do need to talk about previous votes that were taken at some point, and you might have inherited this policy from previous GCs, and I think you did. But the point of the matter is, I've gotten uncomfortable feedback from having to taking a vote to delegate it to staff when I was recused. So I've personally received uncomfortable feedback that was not the proper way to go. So we need to have a process in place, which I do have motion language that I can propose, so we can get a process in place. But I think it's a worthy discussion to revisit what we did in the past and to make sure that we don't need to remedy it in some way. And I think that's a worthy, and if it's not today, then maybe you notice it for a future meeting.
So if votes were taken that were not compliant with state statute in the open meeting law, do you recommend that we revote under a proper quorum anything that we did in the past that might not have been achieved without the proper quorum? Do you suggest we remedy that?
If I may, Madam Chair, I would have to be presented, we'd have to be talking about a specific vote or series of votes for me to comment on proper procedure.
All right. Commissioner Bennett.
Sure, thank you. My understanding is that a big issue that has occurred in the past is the issue of commissioners who perhaps had a conflict voting to essentially delegate their vote to somebody else like the executive director. And the question raised in those situations is, if I am conflicted from voting on this licensee, can I vote to delegate my vote, or is that just as bad as actually voting? So I do see that as a different issue. But one thing, talking about this memo in particular, that I think makes clear is that the rule of necessity is available. It allows commissioners to vote when they otherwise may be conflicted, but it should only be invoked in situations where there is an actual conflict. And all of us as commissioners, I think, care very deeply, not just about avoiding ethics violations, but about avoiding even the potential appearance of an ethics violation. And one issue that perhaps has arisen in many of these situations is that we are being too conservative in abstaining due to a potential but not actual conflict. So that's one thing that this memo, and then looking at some of these cases, made clear to me, is that if a voting member, a board member, doesn't actually have a conflict, but they might be concerned that it might look like they have a, somewhat close relationship with somebody, but it's not an immediate family member or somebody that is actually covered by the conflict of interest law. We, as commissioners, have a practice of being really, really careful and abstaining. But what the rule of necessity makes clear, I think, after reading this, and maybe general counsel can confirm, is that you should not invoke this leniency unless you have an actual conflict. So if we were to go back and look at some of those situations, I think we would need to distinguish between the situations where somebody actually had a conflict and shouldn't have been voting versus when there was just a potential appearance of a conflict. Without going back and looking at them, I suspect most of the cases involved the potential appearance and concern for that, but not an.
Commissioner Roy?
I agree. And I think we should go back and re-examine and talk to the individual commissioner to see what was it, an actual conflict or an appearance of a conflict? And I need guidance on that. So I think, do you agree it's a worthwhile exercise to go back and to ask the commissioners? Because if there was an actual conflict.
How about this? I have a couple of questions that cannot be answered today because I have to get more specific in my questions. So I will raise some specific questions because I do think that there have been some votes that have been taken without due authority. That we have, I mean, again, we know that we received, prior to you being here, that we received inappropriate legal advice that we could be meeting behind closed doors to do our governance documents. And we were found that that was a violation of open meeting law, that should not have occurred. So we do have a history of not getting legal advice that has us acting appropriately. For instance, your predecessor also believed that when there were only 3 commissioners that a quorum was 2, which is not the case. So all I want to do is to make sure that if we have taken some votes that may not, and again, we didn't have this memo rule of necessity, I have asked how you made your opinions. I've asked this in the past. I've already asked it. You said you couldn't answer it in the moment. I still don't have that. About the guidance that you provided when likely there was an appearance of a conflict for someone, and maybe that could have been disclosed, but I've asked that in the past and I still haven't received it. So what I'll do is maybe we can table this. We're going to be having a meeting on the 7th, and then I will clearly write out the questions that I'm asking you. I will once again ask you to provide the opinion, and you'd said that you'd done some research that colored the decision, the legal advice that you gave to other commissioners that they could delegate their vote to the executive director. And then maybe we can have a more fulsome conversation about delegation in general. Because I do think that we have seen a number of instances here, especially given the conflict that we had with Assured, that I still believe was not appropriately delegated. And so we can talk about that too, because as I have stated, the motion language that was used, that you referred to, that allegedly gave the executive director the authority to make a decision that overruled the vote of the commissioners was based on a motion. It was not taken in context, but it was a motion relative to a draft of a piece of regulation. And that language never survived into the final version of the regulation. So therefore, that motion and that language, because it didn't survive into the regulation, means that it's not in effect. So what we'll do is I'll ask you more specific questions so you're better prepared. We can take this up at the April 7th meeting, and then we can move on from this issue. But now we've lifted privilege, so this is a public document. We can have more time to take a look at this. Commissioner Roy, if you have one last question, otherwise we can.
Effectuate that. I have some proposed motion language.
Oh, sure. Okay. All right.
I think the ED has.
All right.
I was gonna put some.
Okay. It's moved to direct the executive director and general counsel to develop a proposed policy establishing a clear and consistent threshold for commissioner recusal from licensing decisions, taking into account the rules of necessity and open meeting law quorum requirements, and to review prior instances in which recusals necessitated delegation of licensing approvals, with findings and recommendations to be presented to the commission within 60 days.
Perfect. Okay.
You good with this?
60 days or?
Well, they have to go through videotape.
Oh, okay. Gotcha.
Right.
Gotcha. Okay. All right. Do I hear a second, Commissioner Stevens or, oh, sorry, Commissioner Bennett?
It is, to clarify, Commissioner Roy, is the intention to go back and review prior instances going back to the creation? Or do we want to only go back 1 year because if something's more than a year ago, the licensee presumably has been approved again?
That's a good
and maybe
point. Yep.
It's a great point, actually.
Go Becky.
So do you have proposed language you'd like to see in there? Do you want me to just put?
I would suggest 1 year, a 1 year
Okay.
back.
Yep.
Because if something is more than a year, then there should have been yet another vote.
Meaning their license.
Their
is
license
good.
would have been
Yeah,
renewed again.
that's a good point. Yeah.
That's a very good point.
But again, you understand my position, and this is, I have been trying to make sure, I feel like I have heard more arguments about implied authority in the last 6 months than I've heard in my entire life. And I've always learned, again, I'm a recovering attorney, that the statute is what controls regulation, and then implied authority. Statute and then implied authority. And we tend to not follow the statute. And that is my concern, is that we have to, one, we need to make sure that we have proper separation of responsibilities, proper delegation. We need to be following. And again, we talked about case law. We've had case law in 2022, which limits, and this was after the September 10th vote of 2020, that further limits the ability of a commission to delegate authority to staff. And so there's a lot of legal issues that are wrapped up in this, whether it's delegation of authority to the executive director, whether it's, rule of necessity here, and whether it's we have a policy in place that allow us to follow at all times the statute, because the statute, rather than implied authority, is what really matters to me. Commissioner Roy.
Yeah, and my understanding in the limited research that I was able to do is that even by voting to delegate the authority, you're still voting on the matter.
Yeah.
You're still voting on the matter.
Right, exactly.
So, and thank you to Commissioner Benedano. If I may reread it with
Please.
the friendly edit, move to direct the executive director and general counsel to develop a proposed policy establishing a clear and consistent threshold for commissioner recusal from licensing decisions, taking into account the rules of necessity and open meeting law quorum requirements, and to review prior instances going back 1 calendar year in which recusals necessitated delegation of licensing approvals, with findings and recommendations to be presented to the commission within 60 days.
Okay. Thank you. And is that enough specificity to give you the ability to provide us with your legal opinion when you told people it was okay for them, or do you need further clarification in that motion?
We'll I think there's enough in that motion too.
Oh, actually,
Commissioner Roy?
the recommendations, I don't know if we could put this, please don't mark them privileged and confidential. So do we need to put that in here so they're not marked?
Why don't you move that this is not privileged and confidential, because we have to be able to. I mean, I just think at this point in time, we have to be able to have a public conversation. And so I think that it's important that we not then have to go back and forth again.
I will just, if I may,
Please.
caution against waiving privilege in advance of seeing a document. I don't think that's a prudent position to take. You obviously are the client and the board gets to waive privilege, but I think as a general matter, it is a more prudent decision to actually look at a document before you start to think about waiving privilege.
We can always assert privilege, right? After we look at it,
Actually, you can't. If you waived it, it's waived.
permanently waived, we cannot reassert.
That is correct.
What are your thoughts?
I tend to agree that I like to know what I'm waiving.
Okay, all
When
right.
I waive something, I think I probably would be inclined to waive this,
Okay.
but again, I'd rather that
The ones we get it.
the memo and then at the
That's
meeting,
fine.
as we begin the discussion, we go to
Perfect. All right. Thank you. All right. So
If I could, and that's, great, but just keep in mind, we will need to discuss this publicly.
I agree.
We're gonna need to discuss this publicly. Okay, so moved.
do I hear a second? Commissioner Benedon?
Second.
Having been moved and seconded, I'll call the roll. Commissioner Benedon? Commissioner Roy?
Aye.
Commissioner Stebbins?
Aye.
Chair votes aye. It passes unanimously. Okay, so thank you. We now are moving on to the overview of the Executive Director Performance Review Form. Does everybody have that was part of the board book, right? That is publicly available. I gotta make sure I have my.
We want to bring Debbie back up?
What?
Should we bring our CPO back up?
Yes, yeah, Chief People Officer Hilton Creek. And you know what? I really like that. Okay, if you could come up, does everyone have a copy of the first thing? And so as Debbie Hilton Creek is coming up, so to just explain, so everybody, is a benefit. Commissioner Stebbins had been working, with prior executive directors to manage a lot of the goal setting. We recognized that setting goals for the executive director needs to be fair, because a lot of the goals that we set for the executive director may be budget dependent. Like if it's setting up a standards testing lab, we can't hold the executive director accountable if the money is not there. So this is kind of a two-pronged approach. One is going to be more heavily on goals, the specific goals for each year. And as Chief People Officer Hilton Creek had initially recommended when we were doing this first form, that CEOs in the private sector, a lot of times you do percentages. I think that this particular review format that Commissioner Stebbins had worked on works better on a percentage basis, because you can sort of see how much, we can gauge based on these concrete items and goals, how that was achieved. This other form is a little bit different. It's not so much concrete goals and execution. It's leadership. It's being responsive to the team. It's being responsive to the authority that appoints and hires, appoints, and oversees. And so, so the first one that we'll look at, because executive director has been here, a month and 2-3 weeks. So I think it's appropriate to use this first form to sort of look at those leadership issues. But I don't think it's appropriate because he's been here a year and it's sort of, going over 2 different budget years. Moving forward, we add that second formatting that is budget dependent. So, so anyway, with that, Chief Hilton Creek and Commissioner Roy and I've got to pull mine up because I don't have mine in writing. I don't know if you do. I've got to, yeah, I know I've got to get on there because again, it's trying to see all the different things and where are we? And I've got to get into here. Sorry. So Debbie, do you want to just first just sort of talk about, where you got this and how you initially recommended this, and then we can talk about some of the changes that Commissioner Roy and I suggested.
Sure. Thank you, Madam Chair. So the initial draft that I had drafted for you and Commissioner Roy, when you requested that I do that for you, I was trying to fashion this off of the same evaluation form that we used for our staff. And so that's the basis on which I built this particular draft. And subsequent to that, both of you had reviewed it and you tweaked it a little bit, and the three of us got together, went over those tweaks that you had done, the suggested changes and edits that you had made, and we ended up with this particular form. I did take it back, and I had worked with our employee, our HR manager or human resources manager, to sort of put a little bit of a format to it so it closely resembled what we were using for the staff. So that's how this particular tool evolved.
Thank you. And so I don't, again, I apologize to everybody because we don't, and this is, I will take a lot of the blame for this. Everything doesn't always get on the agenda or on, in your lap soon enough. It's only sometimes 48 hours that you get to see it because of open meeting. So anyway, I don't know how you'd like to, but I think that we spent a lot of time wordsmithing this. And if there are any comments or, suggestions, very happy to take that back. But does it make sense to kind of walk through and even just, read it? Or, Commissioner Roy, I don't know if you have any thoughts, but it might be helpful to walk people through some of the things that we were thinking and some of the feedback that we got from Debbie when we were doing this.
Yeah, no, thank you. And we did spend a lot of time on this document. We put a lot of thought into it. And, like you said, Madam Chair, there's different tools for the evaluation. So one is leadership and managerial expertise. And then we have, how can you execute on specific goals? And again, some of it's budget dependent. We might not have the funds to stand up a reference lab, so that can impact that goal. But I think the two of those tools give an overall fair evaluation. And you mentioned equity and process and equity, and I think it does that, and I think it accomplishes that. And of course, I'd love to hear from my colleagues who weren't part of this process. And I don't know if the executive director has had time to look over this tool. Curious on his thoughts, but I think we did a pretty good product, but obviously open to suggestions.
So I don't know. I mean, I think it might be appropriate to just kind of walk through and then the public can see this, because obviously, everybody may not have seen this. So these are the different categories: statutory compliance. And the description is aligned with commission statutes and regulations under the direction of the chair and commissioners, establishes short and long-term goals to execute and manage the overall operations of the commission. Strategic direction and vision, adapts to cannabis industry changes, develops strategic plans approved by commissioners, and inspires staff by linking tasks to mission impacts, including public health and safety, economic equity and equality, and industry success. Financial stewardship, oversees fiscal management, budget preparation, procurement compliance, supplier diversity, and financial metrics to ensure efficient and effective use of resources. We might have a typo there, resources. I think that's one word. Operational excellence, drives continuous improvement in operations, systems, SOPs, risk management, internal controls, and performance metrics. Communications, fosters trust and respect through active listening, transparency, clear and timely reporting, public meeting participation, and collaboration with chair, commissioners, staff, legislators, media, and stakeholders. Leadership and culture, models agency values with empathy and integrity, builds an inclusive, high-performance culture, emphasizing professionalism and teamwork, empowers teams to deliver timely and high-quality services both internally and externally. Staff performance management consistently addresses staff performance in a proactive, appropriate, fair, and timely manner using structured processes, e.g. professional development. Well, we don't have enough money for a lot of professional development now, so that is one of those budget-dependent things. Coaching, performance improvement plans, 360 feedback. Effectively addresses interpersonal and operational conflicts, sets clear expectations, provides continuous feedback and training to create and sustain an accountable, productive, diverse, and compliant workforce aligned with agency mission, board and stakeholder relations, maintains transparent communications with the chair and commissioner, staff, cannabis advisory board, legislators, licensees, constituents. Oh, we have a double, okay, as well as public health and safety partners. I'm glad we read this out loud. Goals achievement, plans, executes, and reports on annual goals approved by 3 commissioners. Again, that's the separate thing that we will be also wordsmithing today. Proactively navigates agency and industry challenges, ensures agency and industry regulatory compliance, enforcement, and transparency, promotes public health and safety, consumer protection, and maintains social equity priorities. And then, there is room for comment to provide context. Obviously, each one, there's a grade, but the comments allow people to, say how you reached that grade. Areas for improvement, timelines, measures, list prioritized items with timelines and metrics. Implement staff deficiency protocol with biweekly check-ins, enhance conflict resolution, training for senior leaders. Those are just timelines and measures. So again, this is something that will be, so the commission chair will inform the executive director of the scheduled public performance evaluation 4 weeks prior to the evaluation date. At public meeting. At the direction of the chair, each commissioner will complete an evaluation form and submit to the chair 6 weeks prior to the scheduled evaluation date. 3, commission chair will compile a unified draft evaluation document and schedule a final review with each commissioner for final input 2 weeks prior to the scheduled evaluation date. Commission chair will prepare the final unified document and submit it to board effects. The one question I might have here is if I'm getting individual feedback from commissioners, it probably needs to be initially anonymized. Do I need that to be? Yes. Executive Director.
Thank you, Madam Chair. Through obviously being evaluated in the public setting for quite a while in my career, generally the consolidation of these types of things go through a third party. We would use the town clerk because they were separately elected kind of thing. CPO, I've seen quite a bit, employment council, those types.
Our outside counsel, if you'd like us to do that. Yeah, why don't we do that? I will work with outside labor council on this. All right, Commissioner Wright.
So when you synthesize it to one document, if you have 2 contrary views, let's just pick a category on, I don't know, leadership and culture, and you have 2 diametrically, how do you know which one to pick and how do you synthesize?
But I think that this is also part of how we, what we did previously is we synthesized. Because we didn't do it in public meeting.
If I may.
Yeah, Commissioner
Stebbins. So when you did it before, you synthesize it. So if, say you gave a 5 and I gave a 1, and you gave a glowing review and I gave a very negative 1, what did you do? How did you synthesize that?
Sure. And if I may.
Please,
sure.
Thank you.
Thank you. First of all, appreciate the work on this document. This is something that we haven't used in a while. We really have. It's been a while since we did a formal ED evaluation, but this was kind of a compendium tool with the goals, and those obviously are, collaborative pieces that need to go together. What was done in the past was everybody filled out a form like this, submitted their comments, submitted their feedback. They were anonymized again by a third party, usually the the CPO or whoever was, heading up HR. All of those comments would then be folded together
Okay.
into a document that at the time I would sit down with the ED and go through all of the comments. So the ED,
They were anonymized.
they were anonymized, but everything was given to him. So is,
I think that we can do that and maintain, I mean, it's almost like, I mean, I don't think we let one person do the math. I think that we can have in here, this was the survey. This is where you got 1, 2, 3, 4, 5.
Yeah,
And the next one, 1, 2, 3, 4, 5.
right.
Right? And then we can have the comments. We just don't have, but see the difference
Would you
here.
average the score?
Well, I mean, obviously, then everybody can check my math, which by the way,
Treasurer.
so, yeah. So I would want someone to be checking my math, Lisa. So, but anyway, but the difference here is that the previous executive director did not want to be doing a review in public. And so our executive director is used to this. He's been in the public realm. He's been a town manager. So he's had to go through this. And that's ultimately why we came up with the anonymized, because he didn't want that to be done in a public session. I don't know if you, I mean, that's what I've been told by, I don't know if you heard that. I've been told that by previous commissioners, that they changed the process because the more public version of it was not satisfactory.
and if I may.
Please, thank you.
Sure, sorry. For clarification, when I previously was working on this process that we inherited from the inaugural set of commissioners, I was concerned about us using executive session inappropriately to discuss the evaluation, discuss an eventual salary adjustment. Where we landed was review all of the comment, come out with what we felt was an HR helped me do this to compile a general overview comment of all of the reviews. And then we would bring that to a public meeting where we would have a discussion. Either, I think I, as the commissioner, brought forward a proposal that all of my colleagues, with respect to salary adjustment, that my colleagues would have a chance to opine on, and we would ultimately vote on. But there was the review, the commentary, the summary document was all presented in public.
Commissioner Ray, do you remember?
Well, ironically, the first time was my first day on the job, first public meeting. And so I think I abstained. We did go into executive session. I don't know if you remember that.
He was acknowledging that we went into the commission.
We did.
Executive
So
session.
this would be
We might
August of
have changed it.
2021.
That might have been my first, which is why I felt uncomfortable and felt we needed to
And we did.
fix
To
it.
be honest, we did. We went to exec, now I was newbie, first meeting. And so I listened more than I spoke. And so then we followed up with, because really it has to be around one's character, not the job performance of the ED, right, Commissioner Benedon? It has to be, goes to character and not job performance and evaluation. So Commissioner Stebbins, you're right. That was not the most appropriate way to do it in executive session. So it does need to be done in public.
Yeah.
And that's when you kind of took the reins on that and came up with a form. And we did, I think, I don't remember if we voted on it though. Did we vote, not the form, but on the final outcome of this, the review, the synthesized? I don't remember if we did.
I have to go back and look. I knew we had great discussions about the process, and the chair at the time asked a lot of good questions about the process. I think we ultimately adopted the process by a vote, but I'd have to go back.
Yeah, I think we adopted the process by a vote, but the final outcome, like the review itself, I don't think we voted on that.
Go back. and look.
Commissioner Benedict, can I ask you, describe character. What does it mean under that exemption? I mean, and this is also, as I've admitted, I'm not an expert. And again, I don't like to always put the heavy burden on you to be providing us with legal advice, but when there is, so I think that we have, it's clear that we previously were not following the law in terms of this review process. And there were a number of different instances where we inappropriately went into executive session, and we're working very hard to make sure that we, and again, just today, you gave some good advice. We didn't go into executive session and frankly had a better conversation. But when there is the character exemption, right? What does that mean? What have you seen in your past? Not asking you to opine, but give us some examples of when that is a legitimate reason, exemption, to go into executive session. And I do believe that when character is discussed, that's also when you have to provide notice to that person. And that could be anybody here at the commission. You have to provide notice to that person, and they have the opportunity to either attend the executive session or demand that it be in public, right? Is that kind of a general? So what examples have you seen that reference character? Can you?
Yeah, that's a good question. And off the top of my head, I can think of just a couple that generally, the examples that I can think of involved the honesty or the truthfulness of a person's kind of their trustworthiness, or those are the examples I can think of off the top of my head.
Okay.
So really something that goes truly to character and not just to how they are doing their job. One had to do with, I think, a person in a public health position and statements that she had made, and whether that person was kind of fit in light of concerning statements made. So I think it really does go more to the, I guess I would say, more intrinsic traits of a person.
So truthfulness. Truthfulness, if someone in an official capacity may have not been truthful, would that be one?
Well, I think that still could be difficult, because truthfulness also directly relates to simply a person's job performance.
That's what I'm saying is, where do we?
Right. So if it's, has the person been truthful in their communications with commissioners, for example? I don't know that that's necessarily a question of character. That has to do with an evaluation of their performance. So, like I said, I can think of very few situations where.
But what was the one example that you gave? What was the?
I'd have to.
You don't have to say it, but I would love to get your feedback on that, because
it was right. The one I can think of was something that somebody kind of did outside of their role, but that then raised questions about the person's honesty and fitness to continue in their role. Right. Like if somebody robbed a bank. Right. That would go to their character. It was this specific situation. I don't remember what town, but it had to do with somebody who worked in a public health role, but did some very concerning things during the very early weeks of the COVID lockdown. And it kind of had to do with, the person's character.
Okay, that's helpful, because once again, I'm still trying to be mindful of your advice, when we properly notice things, and whether, and still sort of understanding even the litigation exemption, because in my mind, I had always believed that it was it could be in anticipation of litigation, but it
pretty high threshold.
It's a high threshold. Okay.
Yeah.
Okay. All right. So again, very good. All right. Thank you.
And I will say that with executive sessions in general, a good thing to keep in mind is that the general rule is openness and transparency. So executive session is always an exception to that general rule. And so you really should narrowly and strictly construe the exceptions, because they are really exceptions to the general principles of transparency. So if there's a question, at least given my background, I would say you would err on the side of openness.
Thank you, Commissioner Ryan.
That's super refreshing, because to the chair's point, we did an exercise that cost over $200,000 behind closed doors, the governance, but it should have been done in sunlight. And that wasn't a conservative interpretation of open meeting law. That was a very generous interpretation of open meeting law that should not have probably been made. And so, thank you. That's very helpful.
All right. So again, because we do have this additional meeting next, unless people are not comfortable, there are a couple of typos in here. I would love the executive director to give us his feedback, but why don't you give us your feedback on what you've read here? Because maybe we do a final, because there are a couple of typos, maybe we do a final draft of this next week or the 7th, but could you give us your feedback, your sort of initial, how do we, and I still think that we've got to figure out how to make sure that we are not violating open meeting law, but we are maintaining a process that gives you the most robust feedback, individual commentary, and that however those grades are assessed, I hate to use the word grades, so like, anyway, but that the math is fair to you and that you're comfortable with that.
Thank you, Madam Chair. It was submitted to the packet yesterday, so I haven't had a ton of time to review it. Obviously, just went through it right now. There was nothing that I'm concerned about. I would say as I approach these, obviously, it's a good opportunity for me to get feedback from the board. It's also a good opportunity for me to give feedback to the board. So as long as there's that process where, I have a chance to respond to anything, whether it be improvements or accolades, that's my general approach. And so I certainly, I'm a weird person who likes these types of public performance evaluations. So I don't have any initial concerns, but happy to come back to that April meeting with any specific thoughts.
Right. Commissioner Stebbins.
Thank you, Chair. And again, compliments to you and Commissioner Roy and CPO.
Oh, trust me, you know how long we debated equity versus equality. So anyway.
And I was the scribe, I'll have you know.
Fantastic.
Scribe.
Going back to your secretary days. Commission secretary days.
Yeah.
If I can, a quick edit or suggestion in the top section, who the ED reports to, I guess, should read the commission, not just you, with all due respect. And then
I actually think that is not, I think if you look at the legislature and you look at the legislative intent, I do think that it's the chair, and the statute is very clear that the chair kind of has, this was also, I will tell you, when we were going through our governance process, I was not as vocal about making sure that we follow the statute as it pertains to the unique special authority for the chair to be responsible over all administration and authority of the commission. So that's one of those things that and as you see the legislation coming through, it looks like the legislature is doubling down on their original opinion that the chair does have greater oversight and authority over the administration of the commission. So that would be my only pushback on that.
and completely respect
Thank
that.
you.
Again, mindful that
Yeah.
the four of us are doing this. I guess.
But it includes all the commissioners.
Right. I guess under 3 on your procedures, the chair going back and meeting with each of the commissioners,
May not.
that's outside of a public meeting. I'm worried that might conflict with
Yeah.
open meeting law.
So what I will do is I will work with our chief people officer to make sure that this complies. That is one thing that we'll figure out how we do get that feedback, how we anonymize it, but also, again, it could be getting feedback in open meeting. Right?
Mhm.
So I do think that this is going to be, it's going to be a new process. It's going to be, more transparent. And we're trying to get the right balance here that's follows the statute, but also follows the open meeting law and is fair to the executive director. So, Commissioner Roy, you had another, did you have another?
No, I'm good on that, but I appreciate that because the process is important and we do want to make sure we follow open meeting law and, have a fair process in the executive.
I mean, again,
and you had mentioned that it was, the town, like, who was the person that in your prior experience?
Madam Chair,
please.
Thank you. So, yeah, it was just about having that intermediary to actually do the compilation, the grading, those types of things, so that it wasn't kind of the serial communication issue. And so we used a separately elected individual in that instance. Here, again, either the CPO or employment council, I think, could just be that intermediary.
I think I'm more comfortable with employment council because what I saw in the last go around, and this is not you, okay, is that how frankly but prior people who reported up to the executive director made some inappropriate interventions in a number of different issues. And so this is also part of the tension here, Chief People Officer reports to you. And so I want to make sure that this is.
That it's a neutral.
Right. And so I think that this would be a good use of time with our outside counsel. So we did see a lot of that happening. So.
Madam Chair, if I
Please, thank
may, I
you.
would just say to that point on the procedures at the end of the document, we may want to just be clear on what the expectation is there. But other than that,
What do
again,
you mean the expectations?
I think that as I read it, and again, I just got it, but I think it's said specifically that everything would be compiled by the chair. I don't have it in front of me.
Right here.
So I think we just need to.
Yeah,
just wanna extra-
Chair will compile. So we,
You will anonymize.
oh, we,
I'm sorry, go ahead, please.
yeah, so maybe it's the outside labor council will compile.
Okay.
Okay, and then I think when this comes around next meeting, we do need to probably vote on this
Yes, we do. Yeah,
and
yeah.
put some safeguards in that motion language.
Okay, all right. I think that's good. Okay, please, Commissioner Bennett.
I just want to make a very brief comment commending the executive director, although it is a requirement of the open meeting law. I note that, as Commissioner Roy stated, he has embraced the open and transparent review process, which may not have always been the norm in the past. And one thing that all of us as public servants, but especially our executive director and key staff members, sign up for when they take on these jobs is having things done publicly that nobody in the private sector would ever have to endure publicly. Our pay is online. People can go online and type in anybody's name and look it up. The review process, we're going to sit here and have, who knows, maybe a multi-hour long conversation going in detail as to, our opinions on the executive director's performance. So I just want to acknowledge our executive director for welcoming that and embracing it, and all of the staff here who are public servants and endure a lot more scrutiny than their private sector counterparts would ever imagine.
Thank you. Good comment. All right, thank you. All right, so we will have this back. And again, we have a couple of typos. You have a couple of things that we probably need to work on to make sure that we're tightening up anything in regards to open meeting law. But I think this has been a good conversation. Now, moving to this is the one that Commissioner Stebbins put together. This is supplemental report agency goals. This is, oh, wait a minute, is that, no, where is it? Or did I?
Number 6 on the agenda?
Yeah, sorry, I'm just not looking at it here because I'm not looking at it. Sorry, let me just figure out where we are. I apologize. Oh, no, I printed it out. That's fine. Yeah, okay, so that's what this is, yes, okay, I have it printed out, that's what I was, okay. So does everyone has a copy of the draft? This is 2026, 2027 Executive Director Control Commission goals. Everybody has that? Do you want to just walk through this and we can just in real time, just get some feedback from people? Because there were, some items that I thought, and I think that this is also one of the things that the executive director had asked us is also to provide our input as to what we think should be your priorities, right? Because you can't do everything. Well, I can't, but, so.
And Madam Chair, just through that lens, if I may. So I think the other thing too, and I think we've had some excellent examples that the board's worked through today, whether it be task force, which I've added to number 2 here to consider as you all talk. The other thing is, the working groups for the social consumption. Those are all things that when somebody's looking at their calendar and their meetings are filling up, which I think we've all experienced, how are they saying, I need to prioritize this over that? As we go through this, we have a lot of staff who have a lot of hats, but also, that are participating in a lot of work product. So the more we are able to prioritize, the more it helps for those types of things.
Thank you. I actually think, I was just thinking this year, I think we're gonna have a Phil Eng Award. And I think that it's gonna be the people who are wearing the most hats and doing it most effectively. So, I think, yeah, I know. So we're gonna have to put something like that together. When I was in campaigns and people were getting signatures, we used to give out the Golden Clipboard Award. It was a highly coveted, prize. So let's, think about, nominations for the Phil Eng Award.
I'm sorry, Madam Chair, do you need me for this?
Oh, no, sir. Well, yeah. I think, yeah. All right. So this is, do you need something else to attend to? Okay. All right. So I'm just going to walk through. Okay. Just, so the set of goals allows us to execute a holistic change from calendar year to fiscal year goals, as much of the organizational bandwidth is determined by each fiscal year appropriation. Alternately, approaching an 18-month goal setting process may make sense for quarters 3 and 4 of fiscal year 2026, and then have the dates listed. So anyway, anybody who has any feedback on that, I think that might make sense. And I don't know if the executive director has any comments about the timing on this.
Thank you, Madam Chair. Just noting, obviously, that we've moved our staff to
Right.
fiscal year, and then this would put the executive director on that same trajectory.
Great. So 1, seek improvements or replace IT infrastructure. Again, this is one heavily budget dependent. It's continue to seek alternative or supplemental funding to make needed improvements to the technology platform. This remains a priority as improvements are necessary, regardless of whether the funding comes from a bond bill or through operating budget. So much of the agency's ability to balance personal needs against available funding is based on the ability to improve the IT platform needed for daily functions like licensing. IT resources are required to finally close out Chapter 180 implementation. Again, I think that this is probably the one that's the least fair to grade you on because it's the one you control the least. But I don't know if there are any any comments that you or anybody might want to make in terms of measurement, because it's how do you, when we do get these funds, or how do you figure out workarounds? I don't know if there's anything you might want to think about, so that this is not just, we didn't get the money. So, there may be some creative things that you and Paul are working on together that help us modernize, streamline that. I mean, heck, just what Commissioner Benedon talked about today, that's not necessarily IT infrastructure, but it's using our technology in a smarter way to communicate with the public. I'd love to give you an A on that. We got that done, so.
Thank you, Madam Chair. So I think a couple of things to highlight here, obviously, and the board has discussed this through the budget process and with updates from the CTIO and CFAO. We asked for the medical platform funding, which is later on the agenda. And then, we essentially requested it through the budget, and we went through EOTS, technology security. And so in this, I think what we're trying to identify is really the biggest bang for the buck for this organization, whether it be efficiency for our staff and the tools that they're using, efficiency for, the industry in terms of the licensing process, is really, addressing our licensing software. I think to your point, there are a lot of other examples here. And I think that in responding to this, so what I did last year, and I think just feedback from the board on that would be, the quarterly updates on the goals that were set by the board. And then a lot of things would fall within IT infrastructure. We're placing Mass CIP as kind of the prime example because it will move us as an organization the furthest. But to your point, there's a million different platforms that we rely on, and a lot of examples through the RFI updates that we've had where we're looking to improve those systems, incorporate AI, et cetera. So I think it is a broad one, but I think we just want to identify, if it's not in the title, that Mass CIP is kind of our clear priority of what will move us the furthest.
But if you have other things that you think fall under here that would help us provide you with, certainly credit for what you're working on that might fall under this bucket, I'd appreciate that feedback. All right. Anybody else? Moving on. Institute lab testing protocols and execute strategies to ensure product safety and accuracy. Prioritize review and approval of independent testing laboratory lab testing protocols. Again, that's in process. Maintain commissioners' access to direct consulting from CCC expert engagements in early 2026 as protocol changes are considered. Can you please explain direct consulting? I'm not sure I know what that means or whether or not that, how we grade you on that.
I believe the reference in this example is that when we move beyond package one of the protocols, consulting services that were engaged to build on the next rounds of protocols would be that the commissioners are working directly with them in a prioritization perspective, working with the CFAO. That's going to be, billable hours that we'll need to make sure that we are prioritizing above other costs, but we want you to have access to those resources as we get into the next set of protocols. Additionally, I think separating that from a budget question, I think we also had an excellent conversation earlier today of you all want to hear from the ITLs, so we need to make that happen so that you get their expert analysis. So there's a bit of two different things. One is prioritizing your access to those consulting services in the next couple of months. And the other one is, what we worked on earlier, which is how we'll approach getting you feedback from the ITLs on that.
So the other thing is, we just kind of did it today, but also making sure that the new standing committee is functioning appropriately to move the ball forward based on data. So
I think in that little reference to I&E task force, I think we can now update based on the discussion.
But you're right.
Mr. To the chair, to the executive director. I know it's budget dependent, perhaps, or maybe not. Standards lab, I don't see any language that speaks to that. I just want to get your thoughts.
Please, take it right.
Thank you. I think there's room in here to say that we need to be making progress on that. And I think obviously reference lab within our budget request is one budget dependent item, but standards lab, working with other existing state labs or something to continue to move that needle. I think we could write that in a way that says, come hell or high water, we're making progress.
That's right.
Depending, we'll pick what fits with the appropriation that we have and we'll move forward with getting access.
Commissioner Roy?
Another thought is, we're in the process of looking for our next director of testing and compliance. And we did change the title and we tweaked it slightly. So I don't know if there's room to bake anything going around that under your direction, to execute, to say it,
It just says complete hiring,
complete hiring
but
and execution of new protocols and regulations or something like that.
Mhm.
Thank you.
sorry, if I may, Madam Chair, is people comfortable if I create something along the lines of looking at the options between the standards lab license, the reference lab request, the working with other state agencies and creating the solution? Is that work in terms of the goal?
But I think it's also sort of like immediately looking at public data and establishing a plan for enforcement. And I say that as a sentence that I don't know if it's here, but it's we now have a new resource, which is the public data. And we are going to be doing more with public data. And maybe, I don't know how to wordsmith that here, but it's utilize public data to develop. I almost want, and this is the thing we don't have in here, but it's, I want to time, I don't know how to say this, so I'm probably being a little inarticulate here. Maybe you're going to answer my question before I ask it, so.
Not necessarily to the time frame, but I think within the adjusted scope direction for the task force, I think it's covering what you'd like to see.
Yeah.
All right, okay, all right.
Yeah, I just have a question for edification. So I know we say standards lab and other jurisdictions say reference lab, and you have used them. I don't think you're using them interchangeably. You're saying, because I need a little edification on that. Thank you.
So, and that's a good point, because I think I'm actually working off of your language. So if I'm using it incorrectly, that would be helpful. When I'm saying reference lab, I'm referring to our request within our FY27 budget. It was requested in our FY26 or FY25 budget before I got here for funding to establish an internal reference lab with our own resources. And staff it and have a CCC lab. In the standards lab, I'm referencing specifically within the regulations that is a license type, where the language says you can't be an ITL and a standards lab, and that we have, potential interest moving forward in seeing a standards lab that may come through the licensing process. So I was differentiating those two things. One would be an external party that would be licensed, but we would most likely be contracting with, and one would be us running a lab. And I think that, the director of testing compliance is a position that was specifically designed to say whether or not we operate a lab, we need this director. But if we operated a lab, we would probably need a director of testing compliance and a lab director to actually operate a lab. And so I think right now what we're looking at is options. And some of those options are outside of our control based on resources. So I was using standards lab as the license option where that becomes the resource that we have. The reference lab, if we were to be funded by the legislature and we're moving towards that outcome, and that it has been brought up to us by legislators and others to consider the fact that there are other state-owned labs that we may be able to partner with, certainly a model that exists in other states, but one that we would say probably would take just as long because those labs are not set up to do what we need. So that's how I was differentiating.
Commissioner Roy?
It's helpful. And speaking of standards lab, I did notice an oversight in our regulations. So when we have the fee, the chart of the licensing fees, standards lab is omitted, even though it's a license type. So it's every other license type, and it wasn't there. So for people to apply, there's no fee listed. So there is no fee, right? Technically, there's no fee. Now, we may decide this is such a critical public health thing we need that I don't think there should be a fee, because I think, and so there is, right now, technically one could argue there is no fee because it's not in the regs.
All right, so I think, are we good here? And Executive Director, you and I can work on a final draft of this together, if that's okay. Or do you want to maybe, well, I'll work on this with you unless you want to work.
No, I think that'd be great. I am meeting with Commissioner Benedon and Commissioner Roy tomorrow to kick off our cadence on the management oversight. So if you wanted to be in that, otherwise I'm happy to do it with you, whatever you prefer.
Does what makes sense in terms of goal setting?
Well,
I think that might.
I guess it depends who's kind of taking ownership of that, because if he discusses it with Commissioner Roy and I tomorrow, then it wouldn't be appropriate to have the same discussion.
So
with you.
so this is
best just to
right.
have it with you.
Okay, all
I
right,
think
okay,
so.
okay, that's fine, that's fine, okay,
Yeah.
that's fine. All right, because I see this as a little bit more related to what you guys are doing, but that's okay. It's a document.
Yeah.
Okay. All right, focus on improving organizational structure and organizational culture. With pending legislative changes, social consumption implementation, and regulatory promulgation, the commission must segregate responsibilities of its senior leadership. A recommendation of the SAO by creating checks and balances between departments. This is very important. The ability of the executive director to adjust the senior leadership structure is dependent on commissioner approval, but also the resources needed to create the appropriate levels of senior and mid-management that allow for proper succession of planning and career development opportunities. I think that is pretty, go ahead, Commissioner Wright.
So this is where you're right, and there, I see a lot of overlap here. So I guess what I would say is if you can just stick to it being a document and the language, and don't deliberate, don't get into.
Well, you know what I'm saying. I'm happy to.
No, I think it's appropriate for you and the executive director to land on the language of the document, but you can't get into execution of that.
Yes.
Does that make sense,
Yeah.
Commissioner Mendon? Yeah.
Although we all have the opportunity
To weigh in,
on execution.
and you can't talk to us.
No, but this is also because in echoing what Commissioner Stebbins said, that all four of us have responsibility. Oversight.
Okay, and that's a good point. So I would say when you do have this conversation, then you can't share them with us.
No, that's, yes, okay, right, okay. Okay, CCC, DEI, JB initiatives must continue to be prioritized to build on the work of calendar year 2025. Additionally, the Human Resources Department shall continue to review and update commission human resource policies with the continued goal of providing a positive work environment and sought after place to work. And the CPO and I have to work together, and that will be back on the agenda for the policy book. We need to work on that. 4, undertake implementation of social consumption regulatory framework with promulgation. Met the goal of implementing social consumption, e.g. SOP development, license application build-out, RVT development. Public awareness becomes a priority for the organization in calendar year 2026. Obviously, that's already in process. Allocating appropriate staffing and funding will determine when the organization may be ready to accept license applications on one or all 3 license types under social consumption. And I just raised this here. I do think that we might want to have another kumbaya moment of what all the working groups are, if we can do that within open meeting. So, because, and this is, knowing that Commissioner Commissioner Benedon was having a meeting with her group, which is about publicizing education. You can't really do a lot until, some of these other groups are doing things. So you are acting appropriately and in a timely fashion, but it's sort of waiting for a lot of the other work. So it might not be a bad idea, maybe towards the maybe the 16th, 19th, whatever, that we have a little come together,
Update, like
an
updates.
update from all the working groups, because I do think that working in silos is not a good thing. Okay. Implement operational components of House 4206. The CCC should anticipate the passage of a bill currently being considered by the conference committee. Expansion of purchase limits, change to ownership allowances and medical cannabis program. Again, that sort of sits there. It may be coming out in a couple of weeks. It may be coming out in a couple of months. We don't know. So I think that it's hard to do that right now. And I think that there are higher priorities. Again, we're going to be at some point in time, depending on what they do, this could wipe everybody out, and we won't be doing this, someone else will be doing this. So I just want to make sure that we know what's on the horizon, but we're focusing head down on what we're doing right now. Continued regulatory implementation and education, and promulgate regulatory changes as a result of red tape reduction committee, with regulatory changes to badging requirements, wasting of cannabis products, and the sale of shelf-stable food items. The CCC will focus on their implementation and educating licensees about approved changes. Seek to promulgate changes recommended by the Red Tape Reduction Committee and approved by the Commission. And then ongoing goals and projects, continue to build the Center for Cannabis Research and Policy, support ongoing data collection and research work of the Commission to enhance our cannabis policy research center of excellence, and enhance efforts of the research department, track ongoing developments within the adult use and medical programs that assist policy making efforts. There will be, go ahead, Executive Director.
I was going to add, Madam Chair, I believe we've established in that working group that January 2027 is the goal to be through that process with all recommendations and implementation. So I think we can add that.
Talking about the center.
Yes.
Yeah. And again, applause to our CFAO for having put in place a brilliant idea so that we are not leaving millions of dollars on the table. Expand open data platform. Again, continue to explore opportunities to expand consumer and public access to the open data platform, create a strategic plan, equity program, devise a strategic plan process for equity program that ensures measurable goals and metrics combined with robust data collection and tracking of equity participant success and satisfaction, as well as licensees' equity goals and progress, and present for commissioner consideration at public meeting. Continue ongoing policy work and activities of approved working groups. Continue to allow commissioner and staff time to participate in approved working groups and ongoing assessment to create new working groups or wind down activities of working groups upon task completion. And so now that, we've had an opportunity. One of the things I might want to take a quick break. I don't know if anybody else agrees. If we could take a break now until 3:45. And then I think we're on the downhill slope to getting out here at a reasonable time. Commissioner Roy, I will entertain a motion to recess until 3:45. Do I hear a second, Commissioner Evans?
Second.
Moved and seconded, call the roll. Everyone votes aye. We will come back at 3:45. All right, so, so we are now, I'm trying to think, so we are done with this, and we're going to make any. Oh,
I was saying.
I know. And so, all right, so we are, I can't do that. I can look at how many things are there. That's okay. All right, so we're done with that. And now we are moving on to the approval of medical marijuana patient portal contract funded by the Executive Office of Technology Services and Scrutiny. And our CFAO. And again, we've given you many accolades, but again, thank you for all the work you did, helping us make a positive step forward on our Center for Research. Very excited.
Thank you, Chair. Thank you, Commissioners. So yeah, just to reiterate, as you're aware, in December, we received funding from EOTS for a medical patient portal. Immediately, the team went into procurement mode and we issued an RFR through Combis. It was set up so that there were over 2,000 vendors notified that there was an RFR available through the automatic Combis process. Responses were submitted. We got 4 responses to the RFR. One was deemed unresponsive because they didn't submit the correct paperwork with their applications. 3 others came in. The procurement team had 10 members on it, the procurement manager and 9 staff that reviewed all those responses, came up with some ratings. From there, I can tell you JD Software was the highest rated. We did not stop there. We went and got demos from all of the participants. Demos were done for the procurement team, going through them. They followed up with clarifying and confirmatory questions for the respondents. And then references were checked. So if we go through the slide here, you can see this is for the medical patient portal solution. This is a replacement for MMJOS, but only for parts of it. So if this is strictly a patient and caregiver portal also with the certified health providers. So the allotments will be in metric. The licensees are being moved over to Mass CIP. The agent, so this is a very scaled down version from what MMJOS.
That last sentence, who's going where?
The licensees, the medical licensees have already been transferred over to Mass CIP. So we will now have a licensing portal. MMJOS used to have licenses within it. The agents will eventually get moved over to another system. So it's just the patients, caregivers, and certified health providers that are going to be using this new portal. Allotments will be transferred over to Metric, but they will communicate through those 2 portals.
Please, thank you. And when you say that allotments will be transferred over to Metric, you foresee that? What I hear is patients checking out, it can be timely and they have to, do you think it'd be more seamless now for patients because now it will be in Metric for them?
I would defer to the CTIO on how that actually would work.
Sure, thank you. So the yes, the answer is, the short answer is yes. That currently the process is for all the MTCs, they have to manually, typically, most of the point of sale systems are not integrated with MMJOS. There's only one that's done the work to do that, and even that doesn't always work correctly. Almost all of them, if not all of them, are already integrated with Metric. So this is a simple flip of a switch for them to begin requiring reporting of this. They're already reporting the sales in Metric because it's the standard seed to sale. They're not doing the patient allotment piece of it to date. This will start that process. So and then the patients will still log in through the new patient portal, but it will pull in real time via an API their current allotment from Metric. And so Metric will be managing it, recording the sales history, but it'll be viewable to the patient and to the healthcare providers in the new portal. Yes. Okay.
Can you also explain the sort of 2 optional 12-month extensions? Because, ultimately, that's a pretty long time. And who opts? You know what I mean? Will that have to come back to the board?
Given the dollar volumes, yes, it would have to come back to the board
Okay.
for contract extensions.
Okay, right. Because I do remember when there were some problems, several years ago about Metric. We had someone who had to, move quickly on that because we did not, and again, this is not you, but we should have been more nimble in approaching it. And then we had a last minute approval. And so, this is one of those things that making sure that we stay ahead of it. And again, this is not you, but I do recall being called in at the last minute to sort of give my blessing as chair. And I was a little bit surprised because I think people were afraid to make that extension without a vote of the board. And we did not have an executive director, at that point in time for a few weeks. So I just want to make sure that we understand that any optional 12-month extension will come before the commission with plenty of time, that if the commission determines not to extend, they get to work with you and the executive director to make sure that that's done appropriately. Yes.
Yeah, yes.
Again,
Again, given the size of
Yeah.
it's not an automatic extension. We have to agree to it, and then normally there's an additional statement of work for that year extension, which would go over the dollar threshold requiring the board to review.
Yeah, Commissioner Roy?
Thank you. And if, because I've been on the Access to Medical Marijuana Working Group and speaking with, patients anecdotally, and we know there were issues, right? And so I'm just gonna put it right on the table, and where patients didn't feel like their needs were being adequately served by MMJOS. And here we are, we get this grant, thank you, Lisa. And we go back to JD Software. Do you feel with the team, you said there was 9 or 10 of you, did you adequately discuss the deficiencies, and do you feel they are adequately addressed? So patients are best served?
I think so. I don't know if you want to answer.
Yeah, I'll take that. Yes. We had a number of meetings. As I said, we didn't just do the evaluation of the proposals. We had many discussions for the whole committee. Positives were brought up, negatives were brought up. Those were discussions. We wrote some of these, what we were looking to see into the SOW as far as better reporting, better user experiences. I feel that the committee really discussed this. We had, I want to say, at least 6 different meetings having these discussions going back and forth for the committee. It was not a quick decision because there were some that had questions, and we wanted to make sure we had the best product. We actually had it narrowed down to 2 of the proposals that we were going back and forth on to try to find out which one was the best fit, timeline, cost, what they were offering. And I think that we ended up at a unanimous point where everybody agreed that this was the best fit for the commission at this point.
I just have a quick question. It's following on that. Did we get input from any patients or people, you know what I mean? Did we, because did we take into account at any point? I mean, obviously you're looking at pros and cons and weaknesses, but how did you assess patient experience in this process? How was that done?
We had 2 staff of constituent services and the director of constituent services, and they did raise concerns with the user experience. And again, I think that's what the demo was kind of showing, what the user experience, that's where the demo's focused on what the user was going to see. There is AI functionality built into this next phase of this platform to assist with the users and being able to use those chat functions. Now, again, we have to build in some of the protocols for that.
Can you explain that? Because I think my sister's watching this, and if she hears anybody having to talk to AI, she will probably never speak to me again. So could you explain for my sister, who I know spends time screaming at AI, and when she gets a person on the phone, then she yells at them for having been involved with AI. Can you please explain to my sister why this will work well for patients. And I don't mean to be fresh, but I just heard that story last week.
Take that.
Yeah, please.
So our, first of all, to back up Lisa's point, we look very closely at the user interface and patient experience. In fact, I come from a healthcare background and talked a lot about patient experience and did evaluations. This is a software as a service platform, so it's not just a turnkey walk-in. So we've got ability to still, over the next 6 months as we build this out, provide some context and certainly I think we'd be looking for additional input. So we still have an opportunity to do that.
How would you suggest we do that? Is there, I mean, again, I don't know, but, sorry.
I would want to answer that, now that follow-up.
Oh, all right, okay. How will we incorporate that feedback if we still are sort of at this clay malleable period?
It's partially clay, it's partly form, so we don't have full, but we have used, hard, so I'll have to come up with a better.
Right, come up with a better, I come up with bad analogies, but anyway, yes.
We've used a lot of feedback from the constituent services. There has been one conversation about sending out a survey of patients for additional feedback. We certainly, if the board supports that, that's something that we can work to put out there just to gain feedback. And I think what I would like to do is see us doing that and then doing it on a regular basis so that we can get continual feedback over the years of make sure we're really answering all the patients' needs, even the provider surviving healthcare providers as well, just to make sure, because I think that was one of the loops that was not closed previously. Because the old system was built by the Department of Public Health and we owned it. So any changes to it had to be budgeted. And so that was another component as to why, really the system's 14 years old, has not been changed that significantly. This is the cloud-based software as a service, so it has a lot more flexibility. The answer to the question of the AI, my expectation, and I think the team's expectations in the requirements document was not for it to be an AI chat bot or chat agent or really the interaction with the patient, more of supporting, probably more in the back end for our team for moving.
Is AI going to be talking to people?
No, our plan at this point is not to have AI talking to people. It'll help in the back end to move people through the process and automate some of the back end work.
Yeah.
At least that's our first goal to do that. I agree, especially and our constituent services team they advocate very much for the patients, and we understand that these are those are calling in varied backgrounds, varied interests, varied issues, and expecting AI to deal with that is, I think, is not
I love AI until I really.
They don't.
So I just want to make sure that, that constituents out there understand, medical patients out there understand that it's being used to enhance the experience. It's not used to replace a human being who will be the empathetic voice on the other end of the line, answering your questions. Thank you.
Our wonderful constituent services team will definitely be there.
Okay. You perfectly answered the question. Thank you so much. Commissioner Roy.
Thank you, Chair. So Paul, my question is for optionality. So I've used platforms in the past, iContact, Constant Contact, where I can create content and either email it or text it to a person. And we all agreed that people are more responsive to text than anything. CVS, your prescription will go back on the shelf in 2 days if you don't come. So is that built in any, I don't it can't be that hard to do, right? To message and do text messaging?
The biggest challenge at the moment is I don't believe we've got a full set of phone numbers, especially on the mobile side, for patients historically. So that really is probably the biggest challenge. From a technology standpoint, to send messaging, there are solutions out there, yes.
Okay, so aspirationally, is there a way to make a best effort to get mobile numbers and to get to a point where we're able to communicate that way?
One of the things in the solution, and which is why we went with the team recommended the solution being presented, is the ability to communicate through the portal, through the platform itself, and the new medical patient portal is mobile focused. it's really looking almost a mobile first approach to
Like responsive design.
responsive design, with and simplification of the forms and just an overall process that, you know, the current, you know, you can see that when, you know, around 2005 or 15, when the current site was built, what the technology say was, you know, the web design, definitely this is new, far newer design. You know, and again, phones weren't that big when, or in a mobile environment as they are today. So the new platform is it is mobile first for patients and caregivers.
Thank you, Commissioner Root.
And so if the board ratifies this or approves it, what's the rollout date and how do we communicate that to almost 90,000 patients? And do they have to do anything on their end to migrate over?
We have and at least can talk a little bit more about the specific timeline. So we have the contract is a 6-month implementation from the beginning to build it out and get ready to turn it on and turn it on. In fact, I was just talking with our communications team about the need to begin that communications almost from this afternoon, probably, for people panicking, like, what am I going to do? Like, what happens tomorrow from a patient standpoint? So that's one of the, I don't want to announce our plan is to try and migrate as much as possible. I can't guarantee until we get into the full implementation architecture designs with the vendor. But more than likely, we would be able to bring over some of the, typically when you go through a new system, you want to reset passwords and such, but the existence of the existing patient ID number, because we are going to do this transition of even MMJOS beginning first doing patient allocation for that. So the patient ID number would need to be the same. So we're going to make it as smooth as possible.
And for like an analogy, I think of our phones, right? And we get that we're going to update your operating system overnight and we might not want it. And sometimes I'm like, oh, geez, they updated my operating system. I just learned this one and it just happens seamlessly. Like we don't really have to do anything. This operating system updates overnight. So that's what I was kind of envisioning.
Yeah, I mean, whether we decide from a kind of I forget the word I'm looking for, but if we decide to change maybe the domain name just to make it more consistent, it's a little consistent. It is confusing right now with it's Mass EIP, but it's not Mass EIP.
Yeah.
So we may, if we come up with a naming nomenclature for this platform, then we may want to have a domain name tied to that. That may be the biggest switch, but typically when you do that, you still redirect. If people go to the old, it redirects to the new fairly smoothly. So.
Like rename JOS to a new name? Is that what you're saying?
Correct. Yeah.
If we have a name contest.
We've actually started talking about that internally about potentially how to do that. Because the original MMJOS was because it was the whole entire medical system, and today it's now just a small portion of it. And so something along the medical patient portal, at least what we're using internally was a working term, but certainly
What's the working?
Medical patient portal, MPP.
Sleep.
So I made one already. Yeah, I certainly will work on some of that. But that may be the biggest change. But typically, when you do a domain name change like that, it's just you redirect. So like you said, someone logs in, you're pointed to the new one.
Anything else to add?
No, just again, this has been very vetted by the committee. The references were checked. You can see there's 3 other state agencies that are using this platform. The references all came back very well. Implementation went well. Their services, everything is working fine. So we did, like I said, we vetted this out completely.
Right, Commissioner Wright?
And so the deficiencies of the past, there's safeguards built in here, right? If we see glaring deficiencies.
There is better reporting, better analytics. We've already talked about as soon as if you approve the signature for this, we'll go into an implementation group. Same thing, very cross-functional. Lessons learned. I think that's what's the shortcomings in the past is we didn't have everybody at the table as we were going through this. Everyone needs to be there, whether it's constituent services, INE, IT, finance. We all have to be part of creating what we're seeing and have input from each department so things don't get missed. And that's where you will make sure we have those guardrails, make sure we have those analytics, the reporting, all be there.
So we can hold their feet to the fire through the contract.
Yes, and I think a lot of the problems in the past is it was very siloed when these systems were created so that everybody wasn't at the table, so things got missed as far as internal controls and reporting. And maybe one department doesn't need it, but another department does. The implementation was siloed back in 2018, early on. Not everybody was at the table. Again, lessons learned, we know everybody needs to be at the table. So the implementation group will be cross-functional.
Thank you for the whole group.
Any other commissioners, any questions? No, Executive Director?
Thank you, Madam Chair. I just want to highlight too, I think to Commissioner Roy's point, I think, the CTIO mentioned, obviously, this was a particular system that we did inherit from DPH in terms of the medical. We'll have conversations as we look at licensing that overlaps a little bit, but I think just to Commissioner Roy's point, CFAO put it to me very succinctly because I had generally the same questions. Very thankful, obviously, for the 10 people on the PMT, the procurement team itself. Attorney Ladazinski is working on the contract, Lisa's staff in procurement, Michelle specifically, all the people who did this. We could have gone with this solution by going off the state contract if that was, the end result. The team went through the entire procurement process and came to this result. And so an incredible amount of work that was done to come to this, which is what, essentially answered the same question. And so I appreciate the discussion on it. And I do think that, the due diligence has been done that we feel comfortable.
Commissioner Ray?
Yeah, and thank you. And you said 9-10 people. Are you able to share with us so we can be appreciative of their work, who was on the PMT group?
Sure. Yeah, as we said, Attorney Ladazinski was on the group, CTIO, Jen Clough, project manager. There were 3 from INE. I don't know if I know all their titles, but
Say their names.
Omar Cabrera, Deborah Brown, Dan Huber. From Constituent Services, we had Kate Fisk, Andrew Carter, Chief of Staff, Michelle No from Procurement Manager, myself. Am I missing anybody?
That's everybody on staff.
Yeah.
I think that's
Well,
everybody.
that's a good group and I want to thank them because that's a 58-page contract. And I know Attorney Ladazinski, that's your specialty contracts. And thank you for the work you did on this and for everybody. And I just want to acknowledge, this looks like there was a lot of work and meetings and time that went into this.
And there was, we wanted to get it right, so.
Just one last follow-up. So, Commissioner, in that contract, there are a number of clauses in there on deliverability and in holding them, service level agreements in there. I think it will address a lot of the concerns that you have and others have. So,
Thank you.
Commissioner Roy?
Good.
Would you make a motion to approve this contract? That's right, that you're raising your hand.
no.
It's,
So moved.
Okay, do I hear a second? Commissioner Stebbins?
Second.
Having been moved and seconded, I'll call the roll. Commissioner Bennett, Commissioner Roy?
Aye.
Mr. Stebbins?
Aye.
Chair votes aye. Excellent work. Thanks to the whole team. We really appreciate it. Now, moving on to Commission Research Center Trust Fund for grant applications. You've been complimented enough today to explain it, but just quickly for our minutes, what you have done with the Comptroller's Office and what you need from us. Bottom line is, as I've said earlier, our CFAO and our Executive Director have done very good work. Dr. Johnson has been working tirelessly to create an independent center for cannabis research, independent, meaning the independence of thought, independence of research, but certainly still under the umbrella of the commission. There have been limitations because she has actually been winning what could have been potentially millions of dollars worth in grants. But because we don't get to keep the money, it doesn't really make that much sense for her to have kind of some of those full-time commitments. Because we would like to move forward and to see if we can create additional partnerships, potentially with universities, potentially with private actors, private businesses, to fund both important social policy research as well as biotechnology research, which again is not our expertise, but finding ways that we can both improve public policy, but also find new therapies for people, look at both the positive impacts of cannabis as well as the negative impacts of cannabis, of which, we've heard all of those arguments. So anyway, our CFAO has done a great job saying we can set up a trust. It needs to be approved by the board. But this will allow us to capture some of those funds that then can be used to fund some of the research that we're doing and the staffing that we're doing here, again, with all the caveats, and you've gone through that with us, but maybe if you could just give us a brief explanation. But again, we all applaud the initiative that you took. And I knew you were doing this, but the back and forth and the emails shows, you know, exactly how much work went into this with the control, and it's a very creative response. We appreciate it.
And so what we would do, if we're looking right now is to set up an expendable trust through, we need to get A&F approval. And essentially what there's multiple ways to get additional funds. We're looking for a trust fund. Federal grants come in and they go through the comptroller. That's set up as an appropriation, and we can access that. There are many rules and regulations regarding federal grants as they come in. We are also looking for a trust fund to set up as a separate appropriation for state grants, partnerships. We do not have all the language that as of yet, because I have been working with the Chief of Research to make sure we fully encompass the types of revenue. She's also mentioned, you know, lecturer fees or, you know, again, the partnerships, honorariums, consulting fees. So we want to build a trust fund language that encompasses all that, not just the state grants, but also other funding sources. We do have the paperwork from A&F. We have to go to A&F for approval on the language. They've asked us to draft the language and to draft a budget. So we do not have the full budget from Chief of Research. She is working on that. I did get the revenue sources, so I will be working with Attorney Ladizinski to create that draft language that we can submit to A&F.
Okay, so we've had some motions. So do we need to make a motion today? Will you come back with more specific language for us, or can we vote today to empower you to finalize these details so that we can achieve the goal that we're seeking? What do you recommend? Attorney,
Bring Attorney Ladizinski in for his input.
yeah, and you had also mentioned, does this require any, you know, legislative approval? Like I'm thinking like, you know, like we used to have to do home rule petitions, and I can remember like spending like 3 years trying to clarify a bad, you know, title of two different pieces of property and having to go through that. Will this require like a piece of special legislation like that like a home rule bill would require?
I believe we go through A&F and A&F makes that legislative request on our behalf.
Okay, okay.
So once we draft the expendable trust document, it's in the name of the Secretary of the Executive Office of Administration and Finance, and they're actually the ones who sign it once they approve it. So that is the process of approval. It really goes through that office.
So how do we create the motion for you? Do we just entertain a motion to empower the staff to work with the Secretary of A&F to get the appropriate sign off and legislation to make this? How do you suggest and
I'm not sure that at this point that's necessary, because the only required approval here is from the Secretary of Administration and Finance.
But I thought you said we needed to tell the secretary that the commission is, this is what I'm saying, is that I don't think we need to get into the details. I think we just file a motion. You're on the contract side, but you've been talking with the controller.
We did hear from the financial analyst with the A&F.
Yep.
And that was his recommendation. That's why Attorney Ladizinski wanted to look into it a little further. He did not know if that guidance was accurate.
So do we just, all right.
The only authorization I've seen that is required so far is from the Secretary from the Executive Office of Administration and Finance, that secretary. So, you know, that document that goes to them.
Can you just, if we need to vote on this, can you just get this for us by the next
Yeah.
meeting? Okay, so if you can just double down,
I'll find out.
make sure we need it. You know, I think that we probably have consensus here that this is a good idea to do, but if you need an official vote, just if you can draft that motion for us, I'd appreciate that. Anyway, I don't know if there's are there any questions from my fellow commissioners, but this is really exciting. It is smart that we can take money millions probably that we could have been leaving on the table that we're not gonna leave on the table anymore. Commissioner Roy?
Related question. We need to make adjustments in our research license type because it disincentivizes research. So, Mr. Executive Director, maybe we can formulate a plan on who can tackle the research license because it's not protective of intellectual property and no, who's going to do that, you know? And so there might, and the reason I'm saying that is down the road, there might be partnerships like in Pennsylvania that exists. And so, but right now we have a license type that isn't drafted very well around research.
Could I also ask Attorney Ledzinski to take a look at that and maybe Dr. Johnson, you know, I don't know what they do in Pennsylvania, but this was kind of a back and forth because, you know, in terms of doing research, there are companies out there that would be doing this. And there are only one or two, and I don't think we have any final licenses doing research. But what can we do as a public agency? Because obviously there is a public component to this, but also you don't want, and as we've had conversations with a couple of, you know, larger entities that might even want to fund, you know, some of this biotechnology research. If they're going to do something, they don't want to have to give up their IP. So if you can also be giving some thought to how do we nuance both the public nature of what we do with the need for anybody investing money in research to make sure that they can protect their IP, because I know that some want to, you know, we want to do some research into the impacts of THC. Some companies may want to do research on different, you know, and they are doing some internal research and development internally, but, you know, being able to do something in a more public sense might be good. Executive Director, because I think Commissioner Roy, you had also thought of some ways that we might be able to do this. Executive Director.
Sure. Thank you, Madam Chair. I think for our last agenda item here, where we're talking about kind of next steps on regulatory work, and I know the government affairs team can give us some updates on the red tape. I think there's a few things outside of red tape that I think we've come up with. Actually today, for example, you know, looking at the potential to add into the regs an option outside of accept or reject, you know, potentially amend. We're looking at drive-throughs. That's kind of a separate thing that may come up through the next regulatory process. I know there's a group looking at biennial license renewals, those types of things. So I can add the research to that equation, and we can try to bring that along that same timeline, if that makes sense.
And thank you. I have another question on that, but are we good? So if you could help us think about that.
I just wanted to mention, we do have 2 current consulting contracts with 2 consultants, at least 2 that I know of, where they do vet out the research permit applications. So I know that we currently have 2 contracts with experts who help us in that regard.
So understand the question, because previous thinking was, no, you can't, this cannot be confidential. You can't own this. And so as a result, we don't have it, right? So if there is any, and if you could work, maybe ask the executive director, because obviously if we use a consultant, that costs money. So I just want to make sure that we're asking the right question. It's very narrow, but how might we frame something like this in the future so that research licenses mean something, but also have an impact? One, we're going to hope to get funding and use this internally, but how can we create better collaborations with private industry, with higher education, with, you know, the amazing, you know, healthcare institutions that we have here? It's trying to bring that together. So Commissioner Roy?
I just want to read what I think is the regulation that disincentivizes research. 500-147K, a marijuana research facility shall supply the commission with copies of all final reports, findings, and documentation regarding the outcomes of approved research projects receiving a research permit. Any records received by the commission may be subject to release pursuant to the Public Records Law, Mass General Law, Chapter 66, Section 10, and Mass General Law, Chapter 4, Section 7, Clause 26. Now, knowing that, how do we stay within the law, but are able to help folks protect their intellectual property? Now, someone had recommended maybe they come and present it to the executive director or the chair in person, right? So they go in the executive conference room, and so therefore it protects their IP because it's not transmitted, right? And so we need to think, like, I want to hear how we can't do it. We're gonna have, how can we do it? And that's just one idea. I'm just spitballing.
How can we do it?
How we can't.
How we can't.
Did you?
We want to know how we can.
I was just going to note, that I think your reference to the regs is why I was putting it in that bucket of, we're going to come into the regs. So I think if we can get some responses on options to you all on that timeline on the next agenda item, we can look at 147K and try to get that on at the same time.
Okay. All right, thank you. All right, this is great. Thank you. So moving on to, so we are, so yes, so we will not be taking on that right now. All right, moving on to the red tape removal and regulatory timelines. And thank you. I don't really have a good framework for this right. Oh, Jess is coming. One of the questions I did want to raise, I think I raised this with you offline, and we've had some conversations about a non-enforcement, right? As we're going through this process. And we know that under the regs and rules that we're supposed to be enforcing relegation. And that hasn't been happening, and we're working to figure out how we make that happen. So, going back and forth, talking about as we move forward with the red tape removal, we have a number of different items that we're talking about, whether it's the biennial renewal, but one of the issues that's come up and is the issue of requiring provisional licensees to have a real estate, either a lease or own the property, which has been a huge barrier to social equity applicants. And while I think we've heard a lot of, feedback from stakeholders who are already in business, and we've even heard from some stakeholders in social equity, they don't want, more competition. But I would like to understand the waiver process. And I think I had raised this to you, that we've seen some cogent arguments about why especially social equity applicants should have to be paying rent. And so what is and I don't know if Jess or our general counsel, but our EC's in here, but what is the process? Because we haven't approved a lot of waivers, but it seems like in particular, this is one of those things that as we're looking at changing these regulations, as we recognize that we've seen many barriers, we just extended the exclusivity period. We've seen many barriers, but one of the big barriers for social equity applicants is that huge need to be paying $3,000 or $5,000 as you're going through the process. And then, and then you have to build it out. So can you talk about that waiver process, Lynn, and what that means and whether or not it makes sense to be looking at that right now?
Absolutely. Thank you, Madam Chair. So 2 notes there. On the non-enforcement, I believe we left the previous meeting with a specific date where INE, specifically the co-interim CIEs, are going to review what Government Affairs is putting forward as the prioritization from the red tape and come back with anything that they feel would fit in that non-enforcement category. So we have that coming, and we can incorporate that in this process. On the waivers, and this might be a timeline item where we were covering this in the late summer of last year, but the EC presented numerous times on kind of what is within, what are the waivers that we are receiving. And the conversation from the board at that time was we'd like periodic updates on what is a general outlook of all of the waivers that we receive, because that may impact how we want to approach the regulations. If we're seeing consistent waivers on this regulation, that means that we should consider if we need to amend that regulation. So one of the things that I think that we should be including as well within this, a couple items that we have that fall outside of red tape for you to consider that you've requested over time in terms of regulations that don't fit within the category of red tape. The other thing that we would probably want to bring back within that same general discussion of getting into the regs is an interim update on what are the waivers that we have received, waiver requests that we've received. So just for everybody's people, if they're not following along with every single meeting, the petition process, we got an update earlier on, was a delegation that was lifted formally to the GC. Now it goes directly to the commissioners. The waiver process goes through the Enforcement Council office. They presented kind of a summary of the waivers that have been received, and we can pull that report, but also update it. And then the waivers are reviewed by the EC team. So what we could do is update that report, put that into our look at it, because I think it's good information for commissioners to have. What are the waivers that we're receiving, especially if they're a lot under the same general regulation?
See, my thought is that we generally don't allow them. And so I think that this might be something that rather than having a non-enforcement, it might be case by case, have people file waivers. And it might be something that we want to consider, especially as it pertains to, this is one, issue that I've been concerned with. Commissioner Roy first and then.
Yeah, thank you. So the bane of this is 500-101G56, and it all falls within the application of intent. So when we are removing red tape, if we want to sunset this requirement, which 5 is the identification of the proposed address for the license. 6, documentation of a property interest in the proposed address. The proposed marijuana establishment shall be identified in the documentation as the entity that has the property interest. Interest may be demonstrated by one of the following: clear legal title to the proposed site, an option to purchase the proposed site, a legally enforceable agreement to give such title, or documentation from the owner evidencing permission to use the premises. That is the bane of that. And that is in the application of intent in 500-101G5 and 6. So if we want to, maybe next time we go in, we can sunset that out. And I don't know, I think what you're asking in the meantime, are you saying waiver or non-enforced? Is that what you're kind of?
What I'm saying is it's another option beyond non-enforced, because we've talked about non-enforcement and we've talked about, there may be a couple of different things that we as a commission, because we've seen non-enforcement, but it hasn't been at the direction of commissioners, right? And so there may be some things that we're looking at that we either say, because we are so in lockstep on this and we don't want to wait through, because the regulatory process takes a matter of months and, whatever, it takes a while. So there may be a way that we can provide relief in particular to social equity applicants. But it also takes a headache, off of our. So I was thinking about this waiver as maybe an alternative to the non-enforcement, that this is something that this, the staff can look at and provide us with that. Commissioner Stebbins was after you and then go back to you.
Thank you, Chair. And I'm glad we keep focused on this issue. I've talked about it, you, Chair, have talked about it. We know people that have hung on to property for years, from a provisional approval to finally getting their final license. For me, just to throw some solutions and concerns out there. First of all, that language you read, the language is that required documentation shall include. With tier relegation, it was always a may. We may enforce tier relegation. So I'm mindful of, the teeth that we all intend our regulations to have. So I'm a little worried about the shall and being able to, waive it, relax it, and certainly that's more discussion to have. I guess another option, and at some point, maybe legal counsel could provide us some input into this. I'm right now worried about our social equity applicants thinking about social consumption. Going out, thinking about where they want to establish, their project, their property, their business. If we were to send a message to those folks of we will change this, hopefully that might stop some of them from going out and signing on the dotted line, unless they want the property so bad they feel they have to go and do that. But at least communicate to them, we're going to make this change. I've always hoped that we can move it over to a final license, but for this board to send a message to say, we're going to change this. So before you sign on the dotted line and get yourself committed to something, wait and see how we finally act. But
Do we have consensus? I think we do. I mean, right before we send a message, just want to make sure. Consensus, we're saying consensus
I
that,
think it needs to be either relaxed in some fashion.
yeah, I mean, Mr. Benedict?
On the policy issue, I agree with that. I want to share what our enforcement counsel has shared with me, and I don't know if he's in the room, so I hope I'm not speaking out of turn for him. But part of the reason that the waiver approval rate is so low is that when they consider waivers, a key consideration is whether the request is something that is unique to that particular applicant. The enforcement counsel doesn't want to step into the policy-making role that is reserved for the board. And so if somebody is requesting a waiver of something that is not unique to their situation, but really is just a burden that all licensees bear, and they are seeking an exception, that is not something that enforcement counsel is inclined to approve, because they would be stepping into our shoes. And so it sounds like we maybe have consensus that this is a requirement that we want to relax. And so the question is the waiver process the appropriate vehicle? Because again, that is not something that they have typically in the past done, is to make decisions like this that apply uniformly.
You're not making me argument against myself, because I want to make sure that we are, but it's the whole, but this is the whole point, is that we have had non-enforcement of some items, but it has not been with the endorsement or consensus of the commissioners. So I only raised the waiver thinking it might be an easier path, but you're making me argue against it.
And maybe we are specifically directing enforcement counsel that,
Well, that's right.
it is okay with us if you grant a waiver in this situation,
Right.
even though this is not the type of waiver you would typically approve. But I think that
That's an
if,
option.
and again, enforcement counsel, I don't want to speak for him or his team, but that they may be perfectly willing to grant waivers in that situation if they have approval from us and therefore have the reassurance that they aren't overstepping into our place.
All right, and that is also making sure that we hear about waiver, because
You heard his name a bunch. They're there.
they are running, the hats are flying. Where are they?
Madam Chair.
Executive Director.
Thank you. I just want to note as well, just under the agenda item, this is a question that we've requested feedback from the red tape removal group on. And so I think if the board is looking for that feedback from that group, that would be coming along the timeline of the red tape removals, kind of general feedback on all of these items.
Okay, thank you. Okay, all right, we'll turn this over to you, Justin. Thanks for all the good work you've done, taking the feedback, putting this in order. We really appreciate it very much.
Yeah, thank you, commissioners, and thank you everyone for your participation in the red tape removal. We are still compiling all the recommendations. There were a lot of additional comments that we weren't able to talk about in our in-person meeting. So we're incorporating those into the revision as well. Some staff were actually able to go through that form and prioritize them as well. This specific item, the location requirement, I did just take a look at that, and 10 out of 21 of the members of the external consulting group said do not incorporate that recommendation to remove the requirement for a physical location. So I do want to flag that.
I only.
But these are all.
Thank you, but those are all incumbents who don't want more, and it may, and it may not be people who are concerned about social equity still having an opportunity to access the market. So, and I've also heard people come up here say, we don't want any more competition in the fund. So thank you. And I take that all with a grain of salt. So I appreciate you raising that.
Absolutely. We are going to have this final recommendation list to the executive director, who will bring it forward to the commissioners at a future public meeting. And this is going to include a high level overview of what recommendations they did want the commission to consider. With that, it'll then go into a regulatory timeline, procedure, and use the legal process for that. But so that list is coming at the end of this month. So next Tuesday, we'll go to the executive director for a future public meeting.
Great. Commissioner Roy?
Thank you, Jess. That's really helpful. I can't wait to see that. And thank you to you and the staff that have taken the time to go through them, prioritize them, and synthesize them for us. And, you know, what I did hear, my takeaway is the things that impact everybody, renewals, right? Every licensee has to go through renewals. So that's to the biennial renewal. That will touch everybody and remove some red tape. The cadence on everybody has to go through RVT. Everybody has to badge their employees. The cadence of it, right? The cadence of RVT, you know, we're talking about flipping it from a shall to a may till it's updated, and maybe it's every 3 years, and badging maybe every 3 years. Those are some positive impact plans. You know, I think there should be quality impact plans. And so we're going to, you know, that's something that impacts every licensee. What I did hear from retail that stuck out was letting them discount, like, let's relax that and let them discount. And so that stuck out to me specifically to retail. But anyway, that's very helpful. But the first few items I mentioned touch every license type.
Thank you. I don't know if there are any additional questions or comments. So I think that we have a timeline in this, and we're moving forward on that. We have 2 now, you know, sub-working groups on particular issues that will be a part of this. The other thing is, you know, we probably need to, and maybe you and I, you know, the executive director can have a conversation, but like, you know, what are all of the kind of different moving pieces with, got red tape removal. We've got the, you know, we do have a timeline on the testing, and we've just established that. I'm just trying to think of what pieces in terms of regulatory writing that we need to sort of layer out, because we used to say we're opening the regs. That frankly, the regs should be open. Right now, we have so many changes we have to make. This is an evergreen process. So maybe we can also have a conversation to make sure that we've got the staffing and we've got the, you know, deployment of resources. So any thoughts you have on that, I'd appreciate your feedback.
Yeah, absolutely. The government affairs team works very closely with our legal team, with Rachel and Erica and Mike Baker during all these processes, and especially Rachel and Vanya, they help a ton. So definitely happy to have those conversations with them too.
Commissioner Wright?
Another thought is how we were able to fold in Secret Shopper to exclusivity. So the next is testing. We might be able to fold in like biennial renewals, right? And check that off the box. And then, you know, so
Well, we can, I mean, again, we define the scope,
right.
right? So we can define the scope. It's regulatory changes. We, you know, and this would be, you know, something that we would ask from your team. We don't want to bite off too much, but these are some things that we think. And again, I cannot begin to tell you how emotional I've gotten on a couple of phone calls, talking to different licensees saying, I'm almost out of business. I'm almost dead. And we really, really need this from you and the work that we're going to be doing over the course of the next several months. One, with testing, making sure that people don't have to, that we have better protocols for testing, and we are using our data to, you know, go after the cheaters. But this is like a life and death proposal for a lot of the people who've invested in their business, who have mortgaged their houses, you know, whose families have invested in these businesses. So I just want to make sure that we're responsive to that. So I don't know if you have anything, you know, to add or offer. I don't know if anybody else has any questions, but again, thank you as always, Jess. We appreciate the hard work. You are very organized and you really do a great job on this stuff. So with that, I don't think we have any new business not anticipated at time of posting. I still don't understand how this is even a standing thing in here if we haven't posted it and how we actually approach it. So at some point in time, I'm gonna understand how we actually leverage something like that when we don't have them posted it and we always get yelled at when it's not put. But anyway, I'm trying to figure that out. So anyway, this is not, what's up here is not reflective because I think that the next meeting date will be April 7th. We're still working on the final details there in terms of how we're going to manage that, what's going to be on the agenda. But anyway, so that has not been updated. But anyway, so I now will, Commissioner Benedon, I will entertain a motion to adjourn to April 7th. Do I hear that motion?
So moved.
Do I hear a second, Commissioner Stebbins?
Second.
Having been moved and seconded, I'll call the roll. Commissioner Benedon.
Aye.
Commissioner Roy.
Aye.
Commissioner Stebbins.
Aye.
Chair votes aye. See you on April 7th.